to
so you have
go
each
with the
case
glossary
listed on
under the case. So this is
okay.
the agreement intention to be. So then
right.
And then
yeah,
I
that's
go,
thorough. Good for you.
So then I go through and say, okay, what pertains to all the intention to be legally bound? Oh, Lucy versus Zimmer.
Okay.
So then that way I know what I'm,
right.
And then here was the little note case, the Pepsi case, where the kid said, okay, so would a reasonable person
believe?
Yeah, and then I just kind of went down. So then,
okay.
But it's kind of hard because well, not really if you, it's because I want to, and then I'm going to try to refine it as I go.
Okay, yeah, see, I was just going to put the rules and the elements on my outline, but maybe we should ask them to clarify a little bit.
I think both.
Okay.
Because I have my rules separate from this.
Okay.
Yeah. Because the rules, I think they work in tandem. So
right, because you pull the rules out of the cases.
You split the rule out, and then this is the law.
Like, but I don't know that we need to remember the cases.
No. It's just helping me to.
Oh, okay. Okay, gotcha.
Like you don't have to.
Okay.
But if you can remember.
We'll find out. We'll find out in a few months if I remember.
I take it you didn't have dinner?
Drove.
Oh. How long does it take you to get here?
An hour.
Really?
Hour.
Oh, that's hard.
Hour and a half. On the way home,
No, it's okay.
It's not bad on going home.
Oh, still, that's like you're tired and your brain is right. I'm done. That's dedication.
You drink a lot of coffee at work.
Me too. Today it's a coffee. It's crazy. Oh my goodness. There was a lot of reading, huh? For me,
yeah.
I did that too. Yeah, I like if I can't find a highlighter, I'm like, I can't read.
It's not good. I have to borrow one. But I like variety.
If you need one, I can tell you. Actually, you got the whole box.
Did you get rid of it?
Yeah, I was basically I overheard your friends this week too.
You what?
And I basically did the same thing. Oh yeah, I heard what you're saying about getting furniture this weekend. I basically did the same thing. Oh yeah, Sunday. Okay, never mind. But yeah, I did basically move them this Sunday.
Okay.
And just hauled everything out. And,
did you have it in another apartment or in storage?
Yeah, I basically picked up stuff that people were going to and use that. So I got to keep all the things bounced around. That one photo and right up here.
All right.
I don't want to say guys, because then that's not appropriate. Yeah, no. No, time with your audio.
Good evening.
Renee was in a car accident.
Oh.
Renee, her boss called and said she had just contacted him and said she was in a car accident. I don't know the status of the accident whatsoever. This was about 45 minutes ago.
Oh, do you know whether she was injured?
I don't know. I have no idea. The boss didn't even know. I don't know which. She must have just called and told them we were in an accident. We're waiting for police or something. But I'll get more details. I'm going to try to reach her and see how she's doing. So I'll let you know.
Okay, thank you.
It's in the wire, but she's on her way. I wonder.
Oh, thanks. Too bad. So Renee, yeah,
There it is.
there it is. She's in a car accident. They haven't even got the negligence. Anyone write out a response to the practice question last week? Yes, it sounds like no. That's what they call in criminal law an admission by silence. What happened to the cartoon? All right. So I encourage you to take every opportunity to write an essay response to a fact pattern that presents itself, because you will be asked in the very near future to do just that. And the more practice you have, the more likely it is that you will be successful. Simple as that. Okay. Trespass to chattels. Let's see, last week we left off, the last case we got to was Rogers versus Board of Road Commissioners, and that was, no, we didn't do that, did we? No. We left off on, we just started. Why the hell did we leave off? Did we do Taylor versus Valunga? I wonder if they got the wrong thing up here. You know. Well, I think they have the wrong one up there, but let's go through it. Does anyone remember what the last case was we finished last week?
It would have been.
We had not gotten to trespass the land. Is that correct? You had a definition?
That's the last thing I had.
Okay, what's the definition of trespass to land?
The definition of trespass to land is the intentional entry upon the property and possession of another without consent or legal privilege.
Simple as that. The intentional entering the land of another, and that includes somebody who either owns it or is in possession of it, or both, without consent. So then the question becomes, well, what constitutes entry? And what is the measure of intent? What constitutes entry? What kind of consent might there be? If there's consent to begin with, and the consent be withdrawn. So look at Doherty versus Step, and this was a very old case, and you can tell how old it is because it has a Latin phrase, quare clausum free, which I have no idea what it means. You can look it up. And the answer would be entertaining, but nothing else. Okay, so we can move along and get to where we need to be tonight. This was a case involving an act of trespass. Defendant entered on the unenclosed land of plaintiff with a surveyor and chain carriers, surveyed it, claimed it, but didn't mark or cut down any trees, and that was held not to be trespass. And so the court held there was error in the instructions in that the amount of damages may depend upon acts done on the land, the extent of injury to it. But it's an elementary principle, every unauthorized and therefore unlawful entry into the close of another is a trespass. So for every entry against the will of the possessor, the law infers some damage. So there it is. That's all you need to take away from that case. If it's unauthorized, that is non-consensual, or without legal privilege into the property of another, and then it's a trespass, and you don't have to prove damages. There it is. And so look at note 2 on page 72, a good point, because the cause of action is for exclusive possession of land that belongs to the party with the right of possession. So if it's a tenant, then the tenant would bring the action. The owner might have a claim, but that would require showing of actual damage to the owner, but not to the possessor. Look at note 3, a very important point. The trespass is intentional even when the defendant enters the land in the honest and reasonable belief that it is his own. So you've got some property that is unmarked. There's no fence. One piece of property looks substantially the same as the other. So one person, the owner of or possessor of one parcel, then wanders on to the next parcel. There's no fence. It doesn't look any different. It's just open land or wooded land or whatever. And so the question is that, and that person thinks he's still on his own property. So what? Even if he has an honest and reasonable belief it's his own property, that's not a defense to the tort. And in note 4, nominal damages are awarded if there are no actual damages. Okay, so there's a clue in the next sentence in that note, which explains the behavior of the defendant in the next case, Karen versus Sutherland. In a trespass action, plaintiff will be awarded nominal damages if there are no actual compensatory damages. Why nominal when the trespass does no harm? Why bother? The explanation sometimes given is that the act of trespass is frequently either a suit intended to try title or is directed at the vindication of the legal right, without which the defendant's conduct, if repeated, might ripen into a prescriptive right. Well, I've been able to walk across your land duck hunting every hunting season, and so now I have a right of entry by prescriptive easement. That would be an argument. Okay? Yes, ma'am.
You can sue for nominal damages for trespass to land, but for trespass to chattel, there has to be actual damage to the chattel itself or its owner or his property.
Right.
Okay.
And that may be, as we learned in the CompuServe case, That may be a deprivation of a right of the use of it, or some economic deprivation or damage to some economic right associated with the chattel. It doesn't necessarily mean that the chattel is broken or damaged.
Okay.
Yeah. So, look at note 5. When a trespassory invasion is found, the fact that defendant's conduct was socially useful or even beneficial to plaintiff does not affect liability. Even if the jury, in the Zimmerman case, even if the jury finds that defendant's trimming of plaintiff trees was beneficial to the trees, at least nominal damages would be available. You came onto my land, you took my beehive away because you thought it was doing some harm. Well, you trespassed on my land, even if what you did was beneficial. I didn't give you permission to come here. Okay. Look at note 6. Of course, if the plaintiff does suffer compensatory damages, those are recoverable as well. What about emotional distress? Defendant landlord seeks to persuade tenants to vacate a townhouse, enters the premises without their consent, change the locks on the garage, block the driveway, repeatedly threatened and harassed tenants. In that case, where the alleged trespass is deliberate, accompanied by aggravating circumstances, emotional distress may be damages may be recovered even without physical injury. And of course, in addition to the cause of action for trespass, the plaintiffs in that case would have brought a cause of action against the landlord for what?
Intentional infliction of wound.
Indeed. Sure. And anything else they could think of. All right. All right, moving along here. Look at note 8 on page 74, brings up a good point that is often tested. Since the tort protects plaintiff's right to exclusive possession of his land, traditionally there's been a requirement the invasion be a physical one, which usually must be accompanied by a tangible mass, like a person, a fence, a building, equipment, or as we learned, a bullet. Intangible intrusions, like smoke, they mean such as smoke, odor, light, and noise are not typically actionable under a trespass theory. So make a note of that, because that's the kind of question that might turn up on a law school exam or a bar exam, where you have somebody who is intruding on the property of another by burning something, and the smoke is blowing across to the neighbor's land. Somebody's burning trash, or they're barbecuing some god-awful slab of beef, and the smoke is coming over, and you're a vegetarian and you don't like it, it makes you nauseous. Okay, is that a trespass? The smoke has been traditionally held not to be. What about light? Somebody's got some lights, you know, like my neighbor with his lights that he thinks, what, Russians are coming? You light the place up like a prison compound in the middle of the night? What are you protecting yourself from? So, and why do you live here? Why don't you go into the city where the light, everything's bright, you know? Anyway, so light is not a form of trespass. What about noise? Yeah, and your idiot 14-year-old with his freaking electric bass and drum set, all of that racket comes across my property. Not a trespass, typically. It's something else. Anybody know what it is?
Nuisance?
Indeed. It's a nuisance. Nuisance is a tort. So, if I had a mind, I could sue the fellow in nuisance. I don't have a mind to have a lawsuit with my neighbor, and so I have a polite conversation with him, and we come to an agreement instead. So, let's look at Heron versus Sutherland. Is anybody hot It's only 8. Hopefully it'll switch on. Karen versus Southern, and I'm going to take these just so we can move up to where we left, so trespass to chat. Heron, defendant while engaged in hunting, oh yeah, this is the duck hunter, fires projectiles across the plaintiff's land. It's a shotgun, and the shotgun doesn't fire in a bullet, but rather a group of pellets across the fellow's land. He didn't trespass, he didn't physically step on the land. He was firing his shotgun at waterfowl who were flying over the premises, and he doesn't answer the complaint, but rather allowed his default to be entered, and then there was an award of nominal damages, and the plaintiff, or the court, gave the plaintiff nominal damages of $1. And then the guy appeals. Why would he appeal? Well, note 2 on the previous page suggests a possible answer. The explanation sometimes given is that the action of trespass is frequently either a suit intended to try title or is directed at the vindication of a legal right, without which the defendant's conduct, if repeated, might ripen into a prescriptive easement. This guy wanted to come back and do it again. Okay, but why is this case in the book? It's not for that reason. Why do you think the case is in the book? What principle of law regarding trespass does this case help? Yes, sir.
Well, it's similar to like air rights about the land, like even though it's not the actual land, that is the air or the space above.
Exactly it. And they cite Blackstone, who was a commentator in England, I think in the 18th or even 17th century. I would have to look that up. And late on a Saturday night, when you're bored with your Black's Law Dictionary, look up Blackstone. It's immensely entertaining. So this case is in the book to illustrate the principle that the trespass can occur simply in the air because the owner or possessor of the land has an indefinite right to the air above and the ground below. You can trespass by digging a tunnel under somebody's property. That's a trespass. So that's why the case is in the book. And it is not an uncommon lawsuit, and even now, a few years ago, a group of Texas farmers sued an oil drilling company for trespass because the drilling company had drilled diagonally, so straight down, diagonally underneath the farmer's land to trespass. And in a similar case, the farmers had sued some oil drilling or looking for methane or oil, where the drilling had caused an intrusion of some toxin into the groundwater beneath the farmer's fields. So that was a trespass. All right. In note 2, it's no, look at number 1. Note number 1 on 75. A, disturbed that night by the howling of a cat atop the shed, shoots the cat. Bullet remains in the cat. neither the bullet nor the cat touches the ground. Is that a trespass? I didn't look that case up. What do you think? Yeah, the bullet certainly crossed into the neighbor's land. And in fact, it's still there. Right?
Does it depend who's the owner of the cat?
What?
Who owns the cat?
Well, let's see. That's a good question. It doesn't say who owns the cat, but the point is it's the bullet that trespassed onto the land in the body of the cat. What do you think?
Because the death of the cat would be a totally different tort, right?
Yeah, if it's,
Which
I
is-
suppose
what tort
if
would
it's,
be?
if it's A's cat,
Yeah.
then A could sue for some tort regarding the cat.
Like which
The
one?
good, yeah.
What?
Like which one?
Yeah, well, that's a good
Is
question.
it like
I'm
battery
thinking,
to a cat or like
Chattel?
to a cat?
conversion,
Yeah.
I suppose. How about conversion? You took my cat and you killed it.
Okay,
I've been deprived of my cat.
yeah,
All right.
Yeah.
Try that.
okay.
I don't know. I'd have to give it some more thought. What about air travel? In note 4, the note points out the restatement of torts provides that air travel may be a trespass, but it's a privileged trespass. Air travel is a trespass now only if it enters into the immediate reaches of the airspace next to the land and interferes substantially with the other use and enjoyment of the land. Which of course begs the question, what if you live near an airport and the planes are low flying and it definitely interferes with your use and enjoyment? That might be more in the nature of a nuisance than a trespass. If you had that question on an exam, you would talk about both. Yes, ma'am.
I don't know, I mean, it seems like we usually just not live near the airport. I mean, I'd imagine like the only people that would live near the airport are ones that are okay with the planes and unlikely to sue, right?
Well,
No.
it depends on who got there first.
Oh, they build, okay, yeah.
No, I was gonna ask, do they have to, when, it's kind of a contract question, I guess, do they have to disclose that you're in the air path, the flight path of an airport when you buy a home? That's in the flight path of an airport.
I have no idea. Last year we had sitting in the chair at the end there, a person who was a real estate salesperson and broker who could answer those questions. But I don't know. Gee, I didn't know it was next to an airport. Well, did you? It's right there. Or did you see his plane? Okay, let's now look at Regents Rogers versus Board of Road Commissioners. Maybe somebody can help start this case so I don't rob you of the opportunity. Don't everyone jump up like Jack out of a box at one time. Yes, sir.
I can go, I guess.
Go right ahead. Please do.
All right, facts, Mr. Roger and Kent County had an agreement in which they were allowed to place a snow fence on the property each winter. As part of the agreement, the snow fence would have to be completely removed at the end of the winter. After 2 winters, the county accidentally, they did come and remove the snow fence, but they accidentally left the base behind. Mr. Rogers was out on his tractor mowing. His tractor hit the base, causing him to be thrown from the tractor and die. His wife sued for trespass because the base was owned by the county and should have been moved at the end of the contracted period. The issue is intentional trespass to land. And my rule is intentional trespass to land is defined as the intentional and unauthorized invasion of real property. You want to keep going?
Okay. Why do you think this case is in the book? Since we already know what the definition of trespass is.
Does the base become an extension, like the base that they left behind, or does an object become an extension of your trespass when left behind or placed on the land?
An extension?
Like an extension of the person. That's not.
Oh, I see what you're thinking. So, the road commissioners had the license, they put the fence there, they left this, what was there, a spike or something? And so that was in the nature of it's like trespass by instrumentality.
Yes.
Okay, this, the question raised by this case is, what if you have consent to trespass? Well, he said, the lady's dead husband said we could do this. So now you're complaining. He gave us permission to do it.
But they also, with that permission, gave a deadline, had a deadline to it.
So consent, you can, a consensual entry upon the land of another may be converted to trespass when the consent is withdrawn. That's the only reason this case is in the book. Yes, ma'am.
It's called a continuing trespass?
Well, it also does talk about that.
Yeah.
In other words, it's not a one-shot deal. It was there. It illustrates the point of putting something on the land and not taking it out. But I think that may be related to the issue of the, let me see, I've got a suspicion what happened here. The 1947 case. Governmental immunity. I thought maybe it had something to do with the statute of limitations where you have a continuing trespass and it's past whatever the statute of limitations period is. Let's say it's 1 year and the wife brings a suit in a year and a half, then the argument would be, well, so long as that thing was in the ground, it's a continuing trespass. So the statute, I get the statute continues to run anew with each day it remains in the ground.
I just thought it's continuing because normally trespass would be a person who comes on and off, but this, like, it was every second of every day trespass.
The takeaway from the case is you can have consensual entry, but the consent can be withdrawn. And it can be a continual trespass, but I think that's not good.
So with trespass, there is never any instrumentality.
How about a bullet?
The bullet, okay, that would be that. Okay.
Right. Note 1 is worth reading. At common law, trespass would not lie unless defendant entered the land illegally. As the principal case reflects, the distinction between trespass and case is no longer controlling. Trespass can arise today when a visitor enters the land with the consent and overstays his welcome. Of course, the visitor must be aware he no longer has the possessor's consent. So, note 2, the privileged entry into the land may be limited not just by time and space, but by purpose. You can come in here to do a certain act, and that act only. Note 3 is interesting. In the principal case, the defendant is held liable for the death of her husband from the trespass without any question of negligence in failing to remove the anchor post. Well, certainly today the widow would bring an action not only for trespass, but also for negligence and anything else that her lawyers could think of. But her remedy is not dependent upon a showing of negligence. It's dependent upon meeting the elements of trespass and then proving her harm. And finally, note C illustrates the point that the nature of the damages resulting from the trespass need not be foreseeable. In negligence, as you will learn shortly, one of the tests applied is whether the harm that occurred as a result of the defendant's tortious action was reasonably foreseeable. And with regard to trespass, in that case, the court held that the damages need not be foreseeable to be compensable in trespass. And that was where there was a trespass, and as a result of which the husband had a heart attack. Now, I assume that there had to be some proof of causation, not foreseeability, but there must have been proof of causation. In other words, there must have been medical testimony that his heart attack was brought on by being upset about the trespass. Let's now look at Glidden versus CDTA. Let's have somebody else talk now. We're in the trespass to chattels. Don't everyone raise. Oh, go right ahead, please. ED, please.
Yeah.
Miss, please.
So plaintiff suffered a dog bite, and the plaintiff was a 4-year-old girl. She was going to the store to buy candy, and she saw a dog on the porch of the store, and she started playing with him. And then she climbed on his back and pulled his ears. And so the dog bit her on the nose. The holding was because the dog was in no way harmed or injured, plaintiff cannot be found liable for a trespass. Defendant says he was trespassing when the dog bit her. Plaintiff argues she's too young to be guilty of that.
Liable for it.
Right, so it was the store owner suing the girl for trespass. And so, yeah, chattel has to be impaired as to its condition, quality, or value to be trespassing. And so the issue was, has the party committed trespass to chattel if the chattel is not impaired or hurt? And so the answer is no, there was no trespassing.
Okay, very good. No harm for the dog, so no trespass in chattel. They weren't deprived of the use of their chattel, and so which is another form of harm. Okay. Very good. So your dog bites somebody. Your dog bites this 4-year-old kid. So what do? You sue the kid. You shouldn't have been there. Does the tort trespass to chattel require damages? Yes. The element of trespass to chattel requires some type of harm to the chattel, unless the possessor has been dispossessed of the property. This is not a dignitary tort, so damages must be proved. Why is it not a dignitary tort? Because it's not involving your person, but rather a thing. So, it must be damaged in some way, or you have been dispossessed of the property. So, I go into the courtroom. I leave my bag in the chair. I forget. I walk out. Or I walk out in the hall for some other reason. I come back and some other person has taken my bag, my briefcase. And then they take it back to their office, open it up, and say, oh, I picked up the wrong one. Whose is this? Oh, it's Trussell. I'll give him a call. Mark, would you give this guy Trussell a call and tell him he can come pick up his bag? Phone rings, I say, you're going to bring my bag to me. Is it trespass to chattel?
Isn't honest mistake a defense?
I didn't see that.
Okay.
So is it trespass to chattel?
Yeah.
Has some type of harm happened to the briefcase? He took it back to his office. Okay. Have I been dispossessed of the property? You took my briefcase. And so I would argue it has been trespass to chattel. If you damage it, suppose when I get it back, it's all scratched up, you know? Hey, wait a minute. When I left this in court, it was nice, and it didn't have all this on it, right? This was a nice briefing. Now look, you bring it back, it's all scratched up. I want a new briefcase, brother. I'm going to sue you for trespass to chattel. And he'd say, are you a torch? I want a new, nice Italian briefcase. Anyway, damage. You could have actual damage to it. All right. See what we have on here. Now we move into CompuServe Inc. versus Cyber Promotions. Skip the notes. This is an interesting case because for a number of reasons. A 1997 case, and it was kind of entertaining in that the district judge talking about, does anybody remember CompuServe? Didn't exist. You used to see them all over the place in the 90s when the computer revolution was happening. There would be every little strip mall and everybody. CompuServe was a national company. And it provided an email service. And it's funny, it's the opinion reads in the second paragraph that CompuServe provides its subscribers with a link which allows its subscribers to send and receive electronic messages known as email by the internet. Who knew? All right, so CompuServe is getting screwed big time. And so they go to a law firm and say, stop this, do something. And so the lawyers there say, well, we'll get an injunction. And then one of the lawyers says, but on the basis of what tort? They must be doing something wrong. You just don't get an injunction to stop somebody from doing something because you want them to stop. They have to be doing something wrong. And so all of these middle-aged or older lawyers are looking nonplussed, saying, what am I going to see? And then some bright-eyed fellow who's just maybe working as a law clerk there and going to school at night, thinking, torch, let's see, assault, nah, battery, nah, intentional infliction of emotional distress, leave that down here. How about the trespass to, no, it's not bad. How about trespass to chattel? Give me a memo on that right away. That's I mean, maybe that's how it happened. Anyway, who's going to tell us the story of this case? Yes, sir.
All right, so as we've covered, Cyber Promotions Inc., the defendant, is an affectionately named spam company that sends unsolicited emails to CompuServe, the plaintiff in this case, to the point where customers for CompuServe were actually threatening cancellation while the actual physical means by which CompuServe was doing business to servers and the actual bandwidth was being impacted. So company resources were claimed to be impacted, and the very physical and financial burdens were placed on the company, equipment, and customers. So as covered again, the plaintiff seeks a preliminary injunction on the basis of trespass to chattel, which the rule we're given, the rule I took from it was on 84 from the restatement. Trespass to chattel is committed by intentionally using or intermeddling with the chattel possession of another. And so we must define intermeddling as well. Physical intermeddling means bringing about physical contact with chattel. One is subject to liability to trespass on 4 elements. He disposes of another of the chattel, dispossesses another of the chattel, the value of the chattel is impaired, the possessor is deprived of the use of the chattel, or harm is caused to the possessor of the chattel. So the claim is deprivation for, I suppose it'd be impairment of use. So more, I guess, by element 2 is what's being claimed here, considering the facts. So the issue is,
Yeah,
yes,
show
the show it's been meddled with, and the facts indicate that
interference with the use of it would be sufficient.
Yeah, by its condition, quality, and value.
Yeah.
Yeah. Okay. Yep.
In the nature of being dispossessed of it. And it's interesting, thank you, that the defendants come back and they cite the same restatement of torts, and they say, wait a minute. Unless the trespasser actually takes physical custody of the property or physically damages it, there's no substantial interference. And of course they lost. They cited the previous case, which was Glidden, or the 2 cases back, which was Glidden versus Zabayak, the 1949 case that indicated an action for trespass. The chattel could not be maintained in absence of some form of damage. So I see the 1949 case, and the court said that was 1949. This is the era of emails. So we're going to expand that rule. All right. Interference with the use may satisfy the element. One of the defendant's Hail Mary arguments was that the plaintiff made the business decision to connect to the internet and therefore cannot now maintain an action for trespass to chattel because analogous to an establishment that invites the public to enter its property for business purposes, it cannot later restrict or revoke access to that property. Okay, you open your doors, now you can't. And so you're on the internet, we're on the internet, we can walk into your establishment. You can't say we can't. And the court said, fortunately, that was not your first argument. That was your last. All right.
What page was that on?
85, the second full paragraph. Bless you. Okay, then we come into a new tort, the tort of conversion. Intentional exercise of dominion and control over the property in the possession of another so as to require its forced sale. And by that, you mean you've taken it from me, you took my briefcase, and you didn't give it back to me. And you damaged it so that I've been dispossessed of its use And in its current condition, I don't want it back because you damaged it. And so you must pay me for its reasonable market value at the time of the trespass. In other words, you bought it. Okay? It's a forced sale. So let's move on to the next case, Pearson versus Dodd. Drew Pearson was a newspaper columnist back when people read newspapers. You would turn to the opinion page of many national newspapers or substantial local papers such as the New York Times, the LA Times, the New Orleans Times, Tribune, Chicago papers, any of them, and you would see columns by Drew Pearson and Jack Anderson. And they were political commentators. And then you had Senator Thomas Dodd, who was a very influential senator in the 60s and 70s. His son then became Senator Chris Dodd, author of the Dodd-Frank bill. And so what happened to, what did Pearson do to Dodd? And what was the tort allegedly committed by Pearson against Dodd? Mr. Betancourt, are you familiar with that case?
Yes. Yes, I briefed the case. Sure. The facts are the matter arises from exposure of alleged misdeeds of a senator of Connecticut by two newspaper columnists, and the two former employees, with the help of the members of the staff, entered Dodd's office and removed numerous documents from his files and made copies of them and returned the documents to his office. District Court granted partial summary judgment to Dodd, finding that there was a liability on the theory of conversion, but denied the partial summary judgment on the theory of invasion of privacy. And the appellate court affirmed Dodd's court's denial of the summary judgment for invasion of privacy and reversed its grant of conversion.
Okay.
And then the issue was, did the plaintiff, was the plaintiff able to claim conversion when the the property was returned to plaintiff?
So the court is looking at whether this is a valid claim as to trespass to chattel or conversion, right? So
correct.
And it's not conversion. Why not?
It's not conversion because the original documents were returned.
Yeah, they didn't keep them.
Right.
And so it's not trespass to chattel because why?
Oh, because there was a concern of a public, what was it? public property? I wasn't sure if that was the
It's
reason.
not exactly.
Okay.
So on page 88, it says the question here is not whether the right to keep these files from prying eyes, but whether the information taken from those falls under the protection of the law of property enforceable by a conversion. Oh, I think you may be right. It does not. The information included contents of letters from supplicants and office records, the nature of which is not fully revealed by the record. None of it amounts to literary property. It's or to scientific invention. It's not secret plans. It's not anything. It's not anything in which the plaintiff would have a protected interest. I think you're exactly right.
Okay.
Yeah, a remedy for conversion is forced sale. Okay, you took my documents and I was dispossessed of their use and you damaged them, so therefore you bought them. But the documents were returned, so you can't say that. And the information, you gave me back the documents, but you took the information from them. Okay, and you published it. So it's the conversion of what was on the page, the pages. Okay, why isn't that conversion? And the court said, well, you didn't have a property right. You may have had a property right in the pieces of paper that were taken, but those were given back to you and they weren't harmed. Okay, you took these letters and you got them back, and what was written on those pages, you had no protected right, no property interest in them. It wasn't literary. This wasn't a short story you were writing, Senator Dodd, about your time in the Senate. It wasn't your autobiography you were writing. It had no literary value. It wasn't some scientific thoughts that you had that would be protected under some potential copyright infringement act. It was just letters you got from your constituents, among other things. And so there was no protected right in the content of the pages, and the pages themselves weren't harmed. That make sense?
Yes.
Yeah. Are we done there? Some jurisdictions require there be the possession be that possession by a BFP requires a demand for return. You know what a BFP is? You haven't got that far. A bona fide purchaser. You convert the property and then you sell it to somebody else or give it to somebody else. The measure of damages is the value of the property at the location and time of conversion. You took my Italian leather briefcase, which I bought 25 years ago, and you have to pay me now the value of this briefcase in Indio in 2019. Okay, what's the value of that briefcase? I bought it in New York. Less than what I paid for it in New York, let's say that. Okay. What may be converted? Negotiable instruments can be converted, and those would be possessory interest stocks or bonds, for example. And who has standing to sue? Anyone in possession. Property can be also converted from a converter. There it is. What about the effect of good faith on the, okay, actually, let's look at the notes in question starting on 88. Look at note 3. Plaintiff was holding a $10 bill loosely in his hand when defendant snatched it. Defendant immediately returned the bill, saying, that was too easy. Is that conversion? What do you think? You're shaking your head. Drake?
Yes.
Why do you shake your head?
I'm shaking my head because by the definition of conversion, I don't see it to be a forced sale.
Why not?
The plaintiff holding the $10 bill and taking it from the defendant's hand
Doesn't seem to have affected the bill in a way that would, unless the man's hand was sufficiently sweaty to an offensive degree or harmful degree.
It wasn't damaged to the point where it's no longer of any use to the rightful owner of the $10 bill. He wasn't dispossessed of its use. It was given right away back to him. So no conversion. What about trespass to chattel? What element is missing from trespass to chattel?
inherently.
Right. It's still a perfectly good $10 bill. I wanted to know what the result in that case was, so I looked up Reynolds versus McFarland, the Utah case from 2014, and the opinion never discussed this conversion. There was an assault and battery case, and the question was whether in yanking this $10 bill away from the plaintiff, that was a battery through instrumentality. So if you want to see a full discussion of that issue, Google that case and read the opinion at a website called Justicia. But again, do that late Saturday night. You're burned out on Black's Law Dictionary. And who was the other guy? Koch? Was it Koch or, was it Koch?
Blackstone.
Or Blackstone. And you read Blackstone, retired at 17th century English legalese, right? Okay, then look up Reynolds versus McFarland and see what the Utah courts have to say about that. Anyway, note 4 is worth looking at as a mental exercise. In the following cases, was the interference with the plaintiff's chattel serious enough to warrant an action for conversion? A, plaintiff and defendant owned a house as tenants in common. During a dispute over ownership, defendant notified plaintiff that if he did not remove his furniture, she would have it removed. She did so, informing him of the location. Result, no conversion. Trespass to chattel for which plaintiff may recover only actual damages suffered by reason of the loss of the use of the property. Okay, he had some damage. I couldn't sit on my couch. Right? Okay, fine. What's the value of not sitting on your couch until you got your furniture there? Right? But no conversion. How about B? Similar facts, except defendant removes the furniture to a warehouse at a distance. So plaintiff is subject to a substantial inconvenience and expense to go out and get it. That's conversion. I was dispossessed of its use and I had to go all the way to hell and gone to get it back. Okay, that's conversion. C, similar facts except defendant does not notify plaintiff. Okay, I'm not going to tell you where I took your stupid couch and your chair and the mattress on the floor in your bedroom. I'm not going to do that. Okay, that's conversion. How about D? Same facts or similar facts except defendant stores the furniture in his own name with the intent to keep it for himself. Well, there it is. That's conversion. And then E, similar facts except while the furniture is in the warehouse and before plaintiff can remove it, it's destroyed by fire. Okay, that is a conversion and an insurance claim. Yes, ma'am.
I'm a little confused about conversion. What do you mean by forced sale?
Okay.
So as to require its
The
forced.
guy takes my my briefcase and he or she damages it.
Okay,
I don't want the briefcase back.
okay,
Pay me for it. It's value at the time and place, reasonable market value of that briefcase at the time and place where it was converted. Okay? So in other words, I'm forcing you to buy it. That's what is meant by a forced sale.
so there has to, it's the exercise of dominion and control over the property and possession of another. So it's to require forced sale. So that means there has to be damage done to
Or
it.
you took it, you put it in a warehouse so far away, I'm deprived of the use of it. That may be such a substantial deprivation of my ability to use it that a court might find that amounts to a conversion and you have to pay him for the value of the furniture.
So you have to not want the stuff back? Or like where's the
Well,
line?
presumably you don't want it back, I suppose.
Because I'm not sure where the line,
Well, if it's destroyed by fire, clearly that's a conversion.
right, but
What if it's just damaged, right?
mhm.
And you say it's so badly damaged, I don't want it back.
Okay, but where is the line between A and B?
Let's have a look.
Uh,
Okay, she doesn't remove, she said she removes the furniture
mhm,
and tells him where it is.
right,
Okay, presumably it's not very far away
mhm,
because he can just go and get it
mhm.
and it's not harmed in any way. Okay. She might have to pay him for the cost of transporting it. I mean, they don't really discuss that. You know, you would say, hey, look, I'm not paying for the moving van to go get my furniture. You're going to do it.
Mhm.
B, she takes it so far away. Now, you know, it's in Palm Springs, and one of those storage places with the roll-up metal doors. I'm not driving all the way up there and doing that.
But the same thing, because you just said she would have to pay for the storage van potentially. Why wouldn't B be the same case? Does that make sense?
I think it really depends upon the details of the facts, the effectiveness of the lawyers representing the parties,
Mhm.
and who's sitting up there with their black robe on, and how they decide, right?
Mhm.
You just argue. You would argue. If you encountered this on an exam, you would argue. You would say, it's conversion because there's substantial dispossession of the right, of the possessory right. It's all the way up here in Palm Springs.
Mhm.
And so that is such a substantial interference with the use that amounts to conversion and she should have to pay for it. And then you would argue it the other way.
Okay,
You know, it doesn't matter what conclusion you reach.
okay, right.
Yes.
Professor, I would argue to maybe help clarify. I would say that the defendant notified the plaintiff that if he did not remove his furniture, she would have it removed. And then immediately after, she informed him of the location. So
Because
then,
I'm gonna convert your furniture. I'm gonna tortiously interfere with your possessory right to your furniture if you don't take it away yourself.
yes,
I warned you, I was gonna steal it.
she did dispossess it for a brief period of time, but she did not maintain dominion and control over it by notifying him of where it was actually at. But in B, I would say that because of the fact that there was a removal of the furniture which shows dominion and control, the warehouse was at a distance, and that the plaintiff suffered substantial inconvenience and expense. I would say that is a conversion because of the fact that the substantial inconvenience and expense, that is what may have forced its sale. Is that somewhere along the line?
So Counsel Rodriguez representing defendant in fact pattern A, the tenant in common who removed the furniture, has offered a very cogent argument as to why his client has not
conversion.
not liable for the tort of conversion. Very well said, counsel. Yeah, okay.
Yeah,
That's it. I mean, you just made a very good, carefully reasoned argument. Right. What is the correct answer? That guy or gal is going to let you know. Right? And it's going to be different for different, you know. I mean, there's no right answer. You make your best argument, and hopefully you win. Okay.
Okay.
And you did a good job. I
Thank you.
thought that was good. Right. Does this make sense what I'm telling you about how he just reasoned, you know, on the fact, and he said, hey, it's not really this, and she told him about it or that. Yeah, that was good. Right. And you argue it the other way. Right. Doesn't matter what the conclusion is you reach. You reached your conclusion representing plaintiff and A. She might argue a different conclusion. Just so long as you discuss all the elements and all of the facts, it doesn't matter what your conclusion is. Okay? Does anybody not get that point? It's the thoroughness of how you treat it, not the conclusion that you reach, for purposes of law school.
Yes, sir.
Okay. Okay, class 2 review. Okay, we should have, why wasn't this at the beginning? I don't know. Well, trespass to land and chattels. Oh, that's because, oh, never mind. Okay, so false imprisonment, everybody has the definition or the rule, the elements, intentional, physical, or psychological restraint of another, confines a person to a bounded area without consent or legal privilege. Okay, and so what's a bounded area might be an issue. Maybe the bounded area is you're locked in a closet. Maybe the bounded area was that you wouldn't let them out of the football stadium. Maybe the bounded area is the state of Illinois. I don't know. Like battery and assault, false imprisonment is a dignitary tort. It affects your body. And so damages are presumed. You don't have to prove actual damages, but if there are special damages, harm to your person in some way, then you can prove that, but you don't have to. And then we go to the case illustrating this, Big Town Nursing Home. That's the old man who is put in a nursing home, and his Social Security was stolen from him by the doctor who ran the nursing home, and he couldn't get out. So the point was that even though the initial restraint was voluntary, it may have been voluntary. Plaintiff must be aware he's restrained, although that's not required in some jurisdictions where there's physical injury to the plaintiff. So, and moving right along, awareness of being restrained is an element of false imprisonment. That was the drunken arrest on the golf course, where the trial court decided that the guy, he couldn't remember at trial what had happened. And so the court said, well, you have to be, in our state, you have to be aware of being falsely imprisoned, and you testified that you don't remember it. And the appellate court said, well, just because he can't remember it 6 months or a year later in court doesn't mean he wasn't aware of it at the time. In fact, it seems the facts show that he may well have been aware because he was complaining, kicking and screaming, don't take me out there, according to the police report. So, but the takeaway is you have to be aware of it. But there's a split of authority. Some say if there's physical harm, you don't have to show awareness. Stolen watch lie detector case. Oh, this is where the lady's arrested and taken into the office and examined by the uniformed police officer and the store detective. And she believes that she was falsely imprisoned in that office. And the court said moral persuasion is not enough to falsely imprison So the store representative said, come back into this office and explain yourself. And she thought, well, I should do that. So that's not enough for false imprisonment. And the shopkeeper's privilege simply says a storekeeper, a shopkeeper can restrain somebody temporarily. You're walking out of the Macy's department store and the store detective says, excuse me, sir, we want to step back inside, come into the office, we want to have a look in your bag. That's not false imprisonment, it's the shopkeeper's privilege. We can do it temporarily. You look in your bag, nothing there, let you go. Right? You can't keep them for a very long time. You might have a law school exam where the issue is whether the defendant went beyond the shopkeeper's privilege. Yes.
It has to be a reasonable amount of time, right?
Yeah, what's the reasonable amount of time? You take them up to the office, you look in the bag, and then you hold them there for hours. Right? You lose the shopkeeper's privilege. Right? How about 1 hour? How about 45 minutes? How about an hour and a half? You know,
It depends.
it depends. Just make your argument. The dog leash, false imprisonment. Conviction of a crime for which one is arrested is a defense to false imprisonment. Okay, I was arrested for resisting arrest and convicted of it, no false imprisonment. But in this case, it was a real oddball set of facts where the person is investigated for a violation of the leash law and then arrested for resisting arrest, but then convicted of the dog leash law. Well, that's not a defense to false imprisonment. You look askance. You have a furrowed brow and you're not really sure of that.
No, I understand.
Oh, okay.
Yes, sir. Thank you.
You just always have a quizzical look upon your conduct. Okay. What the hell is he talking about? All right. This was the religious cult case, and that was where the lady was falsely imprisoned on board the yacht in Boston Harbor, and the person who had owned the yacht had a duty to let her off the yacht. He couldn't keep her there. And so the escape, did she have a reasonable means of escape? Well, you would have to what, dive in the water and swim to shore? That's not reasonable. IIED, this is what happens when you get your
Sopranos.
IID bill. Right.
I love your Sopranos.
Okay. So the elements are: the conduct must be extreme and outrageous so as to be, they often say it exceeds all bounds of decency. And that has to be a substantial cause of severe emotional distress. And so the actions have to be intentional or reckless, so extreme and outrageous it exceeds all bounds of decency, and that's an objective standard. That means that it's determined by a reasonable person, not the person who is doing the suing. And whatever the harm is, the emotional distress has to be caused by whatever the conduct was, and it has to be severe. And as we saw in the trash collecting case, it might be just being really afraid and throwing up. Some other court might say that's not severe. This is New Jersey. What are you talking? I'm in the waste management. What's your line of work? Waste management consultant. I read in the Times the other day an interview with David Chase, who is the fellow who created and wrote the series The Sopranos. It's very interesting. He talks a lot about his association with the fellow who played Tony Soprano, and they had little clips of Soprano giving his occupation, which was, of course, committing every crime, within the penal code, from murder on down. Waste management consultant. All right. And that was it. The cause of action for IIED is a separate tort where the defendant's intentional outrageous conduct causes severe emotional distress. Takeaway. And that was an LA case. Silson, which the plaintiff's name. Slocum, that was the case that stands for the principle that we have an objective standard. Was the action something that would provoke an extreme response in a reasonable person? So the question is, would a reasonable person who's standing in line in a supermarket, somebody in the market says, if you want the object, find it yourself, you stink. Would a reasonable person then have a nervous breakdown? And the eggshell skull analysis does not work for determining liability, but rather, once there's liability, it only works to determine the extent of damages. Well, the lady in Slocum and the Slocum versus Food Fair was an eggshell skull plaintiff. Okay. Yes, she was, right? She had a nervous breakdown because somebody said, you stink, all right? If, in fact, she had a nervous breakdown. And as a result of what the defendant said, but that doesn't determine liability. That only tells us what the extent of the harm is. Harris v. Jones, the GM and stuttering employee, that was that decision that just seems so outrageous to us today, where that poor guy is harassed until he's just a stuttering, blithering idiot. And the court said, well, you were already a stuttering, blithering idiot. Right. So there has to be severe emotional distress. The severity of the injury is an element of the tort. People don't write things down anymore. They take pictures of it. That's a habit. I do it myself. Daughter sues for IIED because she saw her father getting beaten up. And the plaintiff has to show either intent to cause severe emotional distress, specific intent. They intended to cause the daughter emotional distress. They couldn't have done that because they didn't even know she was there. Or that defendants knew severe emotional distress was substantially certain to be caused by their conduct. That would be general intent. Yeah, we beat the hell out of the lady's father, but we didn't even know she was there. However, we did know that if we beat the hell out of her father, more than likely, the daughter's going to be upset. So those are two possible interpretations and applications of the element of intent, right? So you would argue there was no, on behalf of the defendants, there was no specific intent. You can't meet the intent element of IIED because the defendant counsel. Your Honor, my client did not even know the daughter was there. Therefore, they could not have intended to cause harm to the daughter. And then counsel for the daughter says, yeah, but when you beat the hell out of somebody's family member, it's substantially certain that the family members are going to be upset. So that's argument. Transferred intent does not apply to IIED. Don't make that mistake. And trespass to land, we've already just saw that tonight. Intentional entry upon the property, possession of another without consent or privilege. beware of negligent trespass and the requirement for damages. So apparently in Fleming's gives a definition including negligence, one who recklessly or negligently as a result of an abnormally dangerous activity such as blowing up dynamite or something and throwing rocks on somebody's property, enters the land in possession of another, or causes a thing, the rocks, or a third person so to enter is subject to liability for trespass. So if you have negligent trespass, according to Fleming, then you can have to prove damages, whereas you would have presumed damages if it was just trespass to land. Intentional trespass.
Should we write negligent trespass down? Because I don't believe we went over that specifically.
Well, at some point, we were finding in years past
Okay.
that students were using Fleming's to study, and Fleming's gives a different definition. And so don't get horsed up with that.
So should
In
I
other
write
words,
it down?
when you're taking the exam in this class, don't say, oh, I remember Fleming saying something about you have to prove damages. Right? No, that's only Mr. Fleming if you're arguing negligent trespass. But here we're talking about an intentional tort. In which case you don't have to show damages. Later on, we will get to negligence.
Oh, okay, so we'll get to negligence.
And when we get to negligence, which is 90% of tort law, then you would argue, yeah, okay, plaintiff may have a cause of action for intentional, classic trespass to land, an intentional tort, in which case damages are presumed. She may have a second cause of action. A prudent lawyer would argue that she may also have, failing the first tort, she may have negligent entry and then argue the facts the defendant was careless. What's this case? The civil surveyor case? We haven't done that. Did we do that? Where is that case?
Yes, sir. This was the first case I believe we did.
Oh, that was I don't remember the facts.
When was this?
The point is, the rule is, the plaintiff will be awarded nominal damages where there are no actual damages, as in the duck hunter's case, where the award was $1. Okay. An honest and reasonable mistake, the land is his, is not a defense. Even socially useful conduct or beneficial conduct is no defense. I thought it was my land. That's not a defense. I honestly and reasonably thought it was my land. I looked on the map. Well, the map was wrong. Okay. Aaron versus Sutherland. You can have trespass to the air above or trespass to the soil above. That's what you need to know there. Consent can be exceeded, or it can expire, or it can be withdrawn. That was the fellow who was killed when the post was left in the ground. And we went through that. Trespass to chattel. You've already seen
Wait,
this.
can you leave that for a second?
What's that?
He went real fast.
Can you leave that one up for a second?
Oh, sure.
Thank you.
Intentional damage or interference with the personal property and possession of another without consent or what if the furniture, claims furniture was in storage and somebody then intentionally damages it or interferes with it? It's a trespass to chattel. Well, this lawyer representing the defendant who allegedly tortiously interfered or damaged the property, you might argue, yeah, but it wasn't in the possession of the plaintiff. You'd lose that argument, but you could make it, right?
What about the previous slide? I think we missed it, both of us.
That one? Somebody had their hand up.
Yeah, the slides, are you gonna send them to us? I use them to rebust by.
Yeah, what we're gonna do is condense, take away all the stuff about the cases and just have the rules.
Okay.
And then put them and make them available to you on the website. And John's gonna do that when he gets back from London, which is where he is now. look at this. Does the tort of trespass shall require damages? Yes, we already know that. We don't need to do this. Let's take a break, 7:26, come back, and we'll get into actually tonight's assignment privileges consent, which goes up through page 137. So we got a ways to go. We got to cover 37 pages. And I will have a simple fact pattern for you to look at the end. Well, I hope Renee, this Eileen, is okay.
She said she's okay.
What?
She said she's okay. They think that she had a headache and her body hurt.
Well, I hope she was not the cause, and I hope the person or persons responsible for that, I'm sure. And if not, I hope that she was sure.
Yeah, and she said she was fully pregnant.
If there's the pain and suffering element, it's not just a.
I'm sure it's in the hospital, right?
What?
Didn't you want to go to the hospital right after?
Well, the only way you can prove that you're hurt, you need medical evidence that you're hurt. Okay?
Yeah.
You can't say, well, yeah, I was hurt, yeah, but you didn't go to a doctor.
Mhm, yeah.
And don't go to a chiropractor.
Oh, that's not a doctor, right?
Chiropractors don't have the letters MD after their name.
Yeah, no, they're not doctors, yeah.
So they're not doctors. They may help you, but they're not doctors.
That's still.
make it till we can make it, right?
Yeah, just keep.
Is it nice?
You're saying you want to go break these cases?
I'm doing this skin. So why did you stop the acting?
You know, I would have tried a lot harder. I would have been a lot more successful at it. I was stupid. I had a great opportunity. Man, things like that.
Ran into the lifestyle.
You know, I just wasn't. I had trouble focusing. I wasn't in the party. I just had trouble focusing. Oh, look, we got an email from the contracts professor.
I saw
Oh,
The slides.
okay.
yeah, what I've learned about LA is it takes about 10 years for most people to establish themselves there.
You need some. No.
I hope Renee's okay.
She said she was fine.
Huh?
She said she was fine. I think they talked. Maybe.
Do you guys have definitions for this class?
That's what we were talking about. We're gonna swap slot pictures until he sends around the slides. But I just have like assault and battery. That was it. I didn't really take pictures.
Like when Eddie goes through them, I've been writing down things that we should have definitions.
Yeah.
And then I go and get my definitions from the Wexler dictionary.
But I can send you the pictures I have of the slides. That's what I was gonna go off of. Is that, you know what I mean?
Yeah, that makes sense.
this cake girl versus driving with the shotgun?
Yes, guy.
Like, they're savage. Boy's like, don't shoot him in the stomach, shoot him in the leg.
I think he lost the leg or something.
Awesome.
Did you read those cases of the first cases in the chapter? There's like 3 of them. Oh, I mean, I didn't even read them. Okay.
Yeah, I read it through.
I think I'm okay. I should have brought more food. I'm okay.
You're pacing over here.
I'm nervous about this case.
Must be nice to be able to go to your refrigerator during class or.
They get to eat it, we know.
Who's that? One day you'll be a professor. You hit dynamite.
Huh.
No, just make it until you make it. Yeah, Drake out there so confident. He's like, I've read everything.
meeting on. Every day, everyone. A lot of the times I'm reading and I feel like I understood something, but then they talk about the case and it was not what I understood.
Kind of like me thinking that was an instrumentality with the stake in the ground. I didn't realize. Like,
It's
I really
confused, some cases.
obviously thought that was the issue. Like,
Do you have a lot of flashcards?
No, they're.
do you need some?
No, I've got some. I just meant like, I'm looking and seeing if you have like this secret stash of definitions that you're just going through.
No, it's just the.
Did you understand that wasn't about instrumentality?
I thought the biggest thing was that it was a continued trespass because after the contract expired, the thing was sticking out of the ground.
Right, that's kind of what I thought.
And it was, because the thing about it was after the contract was over, it was still, they failed, they were negligent. Another thing they bring up is they were actually negligent for not removing it.
Right.
And they were found negligent, but I don't think they argued that.
No, because they're talking about consent on that particular
So
case.
that's one of those things that I should have thought that.
Yeah. So they were saying that the thing ended, so the consent ended.
I was confused.
What did I know? It's
The answer to the whole question about the county and leaving the state behind.
I think he said I was wrong. So I thought he said I was wrong. Yeah.
See, it's confusing. Sometimes I don't understand.
I like, yeah. Those are evidence here, I feel like. I think that's Trestle. Did I reverse it?
Yeah.
Sure.
It's trustful.
That's
Judge
trustful.
Evans is, John Evans is the judge.
I thought he was John Evans.
No, he's trustful.
Call him that.
No, I don't call anybody anything. Like everybody.
Professor. You don't know what his
Professor, sir. Yes, sir.
I say, sir, I don't call anybody anything. I don't make it anymore. When I was in college, weirdly enough, you out there, you can imagine this, I played the violin. I got a violin.
I can see it. You can see
I
it.
mean, this little instrument like this.
Yeah, I can
The
see
only
it.
reason I played it all the way through college is because when I was like 7 years old, this teacher was like, he's gonna be too big to play the violin. And I was like, I'm
For
not gonna be
you. Good for you.
You're like, I'll show you.
So, yes,
The spite is a good
I actually
motivator for
became
you.
proficient at the violin because of this man's pocket. But when I went for my scholarship audition, it was back in the day of the tent dress. Right? The tent dress back in the day, like in the 90s. They were like these dresses that were just like free flowing, like the kind of
Just straight.
yeah, like
No.
no form fitting.
Yeah.
So when I
They're
went,
just look back in.
oh, that's not good.
Oh,
When I went,
they're not flattering to anyone except like models that have like no hips and no thighs.
So I walked into the audition, whatever.
Mm-hmm.
Like I thought that my violin professor was pregnant. So then when I went back the next year, like to her, she was wearing like jeans, they were fitted, and she was like slender again. I said, "Oh, you had your baby." She was like,
That's funny.
so
Yeah,
then,
you
like I
never.
tried to cover it up. I was like, "Oh, it was a dress. It was just."
No, you should have said, "Oh, I was thinking of a different professor." No, that. Yeah. You
So
know.
ever since then, I've been paranoid of making any assumption about
Yeah,
anybody.
you should.
And
Yeah,
so
you should.
I'm
It's
like,
not a good idea.
Sir,
Yeah.
ma'am, like women will walk up to me like 9 months pregnant, I'll just totally ignore the fact that they're
Yeah, until they mention it. Yeah, but
Yeah, when we're sensitive about those things.
I feel so dumb. I'm still like processing it 25 years later.
she might be too.
You're so traumatized.
She might be traumatized as well.
I-E-T.
Yeah,
Yeah, yeah. When does Evans get back?
Oh, I thought it was gonna be a while.
He said in October, sometime in October.
We need those definitions. I need those definitions.
Yeah, right? Those like,
I got most of them down.
Would you like to email them to us?
Can you email me the definitions that you use?
Tony.
You have been elected
I
class
have like 4
secretary.
notebooks all set up.
Me too.
Tell me your thoughts.
Yeah, that's what I thought, that trespass to land, that,
Yeah, copy down all the definitions you said today. And you can scroll, I have a bunch.
It's just don't do the issue, it might be wrong.
Oh,
Well,
no.
where do
Oh,
they
you mean your
start,
notes?
like
Oh,
up here?
no, he'll be
My
like,
issue
why
might
you-
be wrong.
why you-
Or no, the red ones, I think are rules, but
Yeah, just.
I'm just like,
yeah, look at the red ones.
reading this case that I haven't even.
I didn't go backwards, no, that's pretty good.
Can you send us the red one, is that too much work for you? Could you send it to us? I mean, that would be awesome to send it to the class, because we were just all talking about this, like, we don't have any definitions, I mean, you don't get kind of standard.
Yeah, I just said it now, because I don't have Wi-Fi anyway. I get Wi-Fi tomorrow.
Oh, that's awesome.
We can't even get Wi-Fi, like, I got a hotspot,
Why?
because we're in the middle of nowhere.
Here
So
or you mean
no,
your house?
There at
Oh.
the house, and so got a hotspot last week, we fall outside the boundaries of the hotspot. So now, paid for a hotspot, and a cell phone plan that didn't even work at my house, like I bought my tornado, that's my phone. And I was like, oh, we'll get this one, I'll get the hotspot, and then we got home, and that don't work at our house, like, they don't work till we're happy if I'm dead.
Okay, so. It looks like I have 7 definitions.
Okay, the password here?
No,
The internet?
for the LSAT thing.
I was gonna say, did you need a password for our, 7 sounds about right. At the end of,
September.
that's for the California bar. That's to register as a law student, that's the
Yeah,
end of
yeah.
September.
That's what I mean.
I just get rid of those shit.
Yeah, that would be good.
Forget, exactly.
Thank you.
Very well. Yeah, just, email me back and let me know if I'm missing anything or feedback. Yeah, that was probably you guys.
Oh, you know, my, the last email you sent, I didn't get it because the email. Right email.
Yeah, write it down.
It's just, it's the same,
Okay.
except after MM Lagos,
Yeah.
7-5. Yeah,
Goodness.
weird.
Bring it in, I'll read it.
Oh, yeah? I'll give you a summary or something.
Sounds interesting. I remember, you went to Santa Cruz? Who was somebody in here went to Santa Cruz? Oh,
We
yeah.
did, you sent it first.
Where did you go? I forgot.
Bananas love, yeah.
I didn't write it down.
Where do you go?
Are you asking where I was?
Yeah.
The College of Worcester.
Oh, that's right. I didn't write that. Where's, oh, yeah, that's right. Worcester. Where's that?
It's in Ohio. Worcester, Ohio. It's an hour south of Cleveland, just right smack in the center.
I think I know about Cleveland. That's the Cleveland Orchestra with Eugene Ormond.
It's a nice center. I've seen it.
One of the best orchestras in the world for a long
Yeah,
time.
yeah. I had no idea.
I was in Cleveland once, in the dead of winter, and taking a week of depositions in a breach of contract court case, and took the train from the airport to this hotel. The train actually took me to the hotel directly. I never had to go outside, but I did go to hear the Cleveland Orchestra. So, you see Santa Cruz, there were some real brains there,
Yeah.
60s and 70s.
Yeah.
I remember this one particular who wrote a book that really fascinated me. It's called Wittgenstein's Vienna. It's an interdisciplinary approach to history. Anyway, moving right along, CompuServe. I think we left it. We did CompuServe, did conversion, Pearson versus Dodd. The defenses to torts. Here we are, O'Brien versus Cunard Steamship Company. That was a big, boy, you went across the ocean, you sailed on Cunard steamships. Who's going to tell us about this case?
I can try.
Wait, no, you can't. You will try. You can do it. So
Okay. So let's see. So I have here the facts. Plaintiff sued for assault the steamship Cunard after suffering ulcers due to vaccines. She alleges she did not give consent. Defendant was given verdict. Plaintiff is bringing exceptions, which is, I guess, an objection. And there was a quarantine on the boat, and vaccines for smallpox were needed to get off the boat. Notices were on the boat, or were clearly posted. And when her time was up, her arm was examined by the doctor, and no signs of previous vaccines were in sight. She says she had been vaccinated before. However, the doctor did not cure her. Defendant heard no objection. Her conduct demonstrated that she wanted the benefit of the vaccine. Let's see. Okay, and my issue is whether a surgeon's conduct is unlawful when considering surrounding circumstances. I'm not sure that's the issue. And my rule is consent is given when conduct and behavior demonstrates approval of surrounding circumstances. The doctor was guided only by her overt acts as manifestations of her feelings.
Okay. Thank you.
You want my conclusion? Or?
Sure.
Okay, it says defendant's conduct in light of circumstances was lawful. There is no evidence showing that it was not. And the holding was exceptions were overruled.
Yeah, forget the exceptions overruled. I don't even know what that is. I guess objection. Anyway, but
yeah, guide me because I don't know if I'm doing this right.
What?
I don't know if I'm doing the
you're
reading
doing fine.
right.
So they call this an action for assault, which in fact I think they mean battery. And she loses. She had a bad reaction to the shot. So the takeaway from the case is one of the defenses to an intentional tort is consent. And the court there found, you saw everybody lining up, you knew it was 4. You never said anything. So the doctor quite reasonably assumed that you assented to it. So what are we doing here? In a nutshell, right?
Give her the shot.
What?
He gave her the shot.
Yeah, so when she lined up, her behavior was such to indicate the doctor was justified in his act, whatever her unexpressed feelings may have been. So I don't know what that is. Okay. She and other women were assembled and examined for a vaccination scar. See whether they had been vaccinated. If there's no scar, they were vaccinated. They got a certificate. She hangs back, told the doctor she had been vaccinated. He finds no scar. He vaccinates her. She has side effects. Sues for battery. Defendant asserted plaintiff consented. She held out her arm. Must consent be expressed? In other words, does she have to say it? Right? Or can you find consent by the plaintiff's actions, which is what you were saying? Right? The answer is consent does not have to be expressed, it can be implied from conduct.
I have a question.
Yes.
So when we read these cases, the rules are, I don't know, very lengthy, so it's okay for us to do this, to shorten them?
Yeah, right, so these cases, some of them are quite old. They're from different states, different jurisdictions, different times. The rules may be stated differently, somewhat differently. They may be longer, they may be shorter. Sometimes they're quoting the restatement of torts, which is a good guide, but it can be condensed. And so this is good enough. Reading the case law has several functions. It illustrates, the opinions illustrate the law that we're studying at the time as applied and developed by whatever court the case is from. It gives you the exercise of reading case law and then finding in that case law the rule, extracting from that, because that is what lawyers do. You read the case and then you say, aha, there's the rule as was applied on those facts. And so therefore, you now take that and you argue that it should apply to your facts. You may have laws though that are not derived solely from a case, but also from a statute, criminal statutes. Right? But even though it may look simple in the statute book, the question is, how is that interpreted and applied in an individual case? Well, as a lawyer, you would argue from the plain language of the statute that it should apply to the facts, but also you would go to the case law where the statute was applied or not applied, and you would argue, gee, just as in the case of People versus Alvarez, Your Honor, where the district attorney argued that this criminal statute did not apply, so too in our case, which is substantially similar, we assert that it should not apply. So you're arguing both the statute and the case law. So the point is that you read this stuff so you can extract the relevant parts from it, because that's what you will be doing. If you can't remember the name, this is what my criminal procedure professor told us, I remember. If you're ever arguing a criminal case, you don't have a case in support of your opinion, but you can't remember it. But just say, People versus Alvarez, Your Honor, because there's about 300 of those. So, anyway. Consent may be expressed or implied by conduct, expressed or expressed. I hereby give consent. And looking at the notes, that was the case of Malloy, note 1 on page 98, the case of Malloy versus Hop Sang, the 1935 case where the patient arrived at the hospital with a badly injured hand, wrapped in cloth, told the surgeon to fix the hand but not amputated it because he wanted to have it looked at in his hometown. The surgeon replied he would do whatever was necessary once the anesthesia was administered. And he was able to get a look at the hand. The patient didn't say anything. The surgeon amputates the hand. The appellate court ruled consent had not been given where the patient with limited English did not reply or make objections to the surgeon's statement, and that he would do whatever was necessary. Just look at the facts. They show consent or not. Note 2, suppose in the course of an argument, defendant announces he is going to punch plaintiff in the nose. Plaintiff stands his ground, but says and does nothing, and defendant punches him. Is that consent? You're shaking your head, sort of.
Yeah, I would hope there'd be some kind of provisions like attached to this, like some kind of temporal concern, because like if it's just like, oh, you didn't move the instant I was ready to punch him.
Can you commit a battery if they don't say anything? Is there a free poke? Get it? Or is there consent? Well, when you play football, you get punched and you get kicked and you get hit, but you consented. So, does this arise to consent? I'm going to punch you in the nose. And the person says nothing. He doesn't put up his hands. He doesn't turn and leave. He just stands there. We would argue it's consent. I'm going to punch you. Make my day. Okay. On a park bench in the moonlight, a young man informs his fiancée he's going to kiss her. She says and does nothing, and he kisses her. Is he liable for battery? What if it's their first date? What if he is a stranger who just sat down next to her and he makes the announcement? I'm going to kiss you. And she says and does nothing.
I see a bunch of the issues that are coming up with me too about what, or like if they felt they had to consent given the circumstances. Aren't those the issues being raised?
Well, she says and does nothing. Is it consent? So he kisses her and she said, I didn't give consent. But you didn't say anything, you didn't move, and so.
Well, then maybe she felt too uncomfortable to, maybe he was in a position of power and she didn't feel like she
That's an argument.
Yeah.
Right, that's it. What if it's their first date? I mean, you just look at the facts here. If it's a total stranger, yeah.
No, but just look.
Okay.
Yeah.
All right. They don't really give you enough facts here in these little notes to reach a conclusion. Hackbart versus Cincinnati Bengals, which is a group of humans in a sports team, not a group of tigers that happen to reside in Cincinnati. What happened in this case?
Professor, I'll do it if you want.
Yes, sir.
I have some questions about it, but I'll do it.
No, go ahead.
Thank you. Let me try first to state the facts. This is the case of Hackbart versus Cincinnati Bengals, 1979. And basically, Dale Hackbart was a defensive back for the Denver Broncos, and there was a play in which he was hit by Charles Booby Clark of the Cincinnati Bengals. Clark had basically taken his forearm and hit Hackbart in the back of the head, and they both fell forward, and the play was over. So Hackbart was a defensive back, so obviously he must have interfered with the play somehow. And so the issue is, can a player be held liable for intentionally striking a blow to someone which occurs outside of the rules of the way the game is played? The court had said that football is an inherently violent sport, and although Clark had intention, he acted out of anger and frustration, the authors tell us, but he didn't intentionally plan to harm Hackbart. But the issue is also that although it was violent, there are rules established of professional conduct, specifically no blows to the head. And so the conduct was outside of what was normally allowable in football. And the courts had said that Hackbart had a right to a remedy, and what would his remedy have been except to retaliate? So that therefore it had to, the conclusion of the case, I believe, Professor Tussle, was that they had to remain, I think I looked under the, they remanded it for a new trial because they needed to see if, hold on a second. They needed to further assess if his rights had been violated by the blow. Is that correct?
Well, yeah. The last paragraph reads, in sum, having concluded the trial court did not limit the case to a trial of the evidence bearing on defendant's liability, but rather determined that as a matter of social policy, the game was so violent and unlawful that valid lines could not be drawn. We take the view that this was not a proper issue for determination. Plaintiff was entitled to have the case tried on an assessment of his rights, whether they had been violated. So, just because you consent to play a violent sport, in this case, football, doesn't mean you consent to everything that can happen while you're playing. You consent to play football according to the rules of football. And those rules provide players are prohibited from striking the head, face, or neck with the heel, back, or side of the hand, wrist, forearm, elbow, or clasp hands. Thus, the very conduct which was present here is expressly prohibited. He didn't consent to that. He consented to whatever normally happens in football, right? So, how would we state that? Did plaintiff consent to being struck just because he participated in the game? A player impliedly consents to conduct within the rules of the game. If conduct outside the rules may exceed the scope of consent. And the example is Mike Tyson, who's a boxer, is in a boxing match with a fellow named Evander Holyfield, and Tyson bites his ear. And Holyfield sues. And Tyson says, it's a boxing match. You consented. We're fighting for the heavyweight championship of the world. And Holyfield said, yeah, I consented to being bashed in the face by your impact that was probably 1,000 pounds per square inch. It's going to give me brain damage. I consented to that. I didn't consent to you biting my ear. That's not our rules. So in California, consent to participate in recreational activities is a huge area of tort law. When you participate in recreational activities, whether it's skateboarding or skiing or football or any kind of recreational activity, and somebody is injured seriously, and there's a lawsuit, the defense is always consent. And the argument is always, what was the scope of the consent? I agreed to participate in, let's say, horseback riding, a horse race, but I didn't consent to you pulling up alongside and with your spurs and kicking my horse and causing it to throw me to the ground and be hurt, for example. And these things are litigated. You wouldn't believe the amount of litigation in California over the issue of the defense of consent to participation in recreational activities. Published opinions on that like you wouldn't believe. It's incredible. So, by way of example, a case that was up in Visalia several years ago where a 12-year-old girl in a middle school is out on lunch break with two other boys, and they're playing catch with softballs and mitts. And the boys it's a triangular pattern, and the two boys are throwing balls to her, and she's catching them and throwing them back. And so one of the boys throws the ball. she doesn't, two people are throwing stuff at her. And one of them, the ball is thrown with considerable force. And she doesn't catch it. And it hits her right in the forehead and crushes her skull, as would a hard-boiled egg shell be crushed if you took it and you smashed it. The skull was cut out with a little saw, and then a screen, like it looks like a wire, fine wire screen, titanium, is then placed over the hole, and then very fine holes are drilled. The kit that the doctor buys comes with the drill bits, and the saw, and drill the holes, tap them, which means put threads in them, in the bone, and then screw these little screws down in to hold that screen or plate. There's a support screen and then a plate over that, and then the face is then put back on. So to do the operation, the face is cut and then folded down so the face is, you don't see it, it's just all red flesh. And then it's put back up and then sewed back on above the hairline. The hair goes back in so you don't see the scar. So the case was against the school district for negligent supervision. And of course, the defense is consent to a recreational activity. Counsel, why are you bothering us with this? You know that this is a valid. Well, she consented to what? You say she consented to a sport, so the question is, what sport were they playing? It wasn't boxing, it wasn't football. Sure as hell wasn't baseball.
What type of ball was this? They picked
Softball.
Oh.
Which is hard as a rock.
Yeah, they maybe, this school district might be liable, I guess, for allowing them to have softballs,
So
right?
the case is one for negligent supervision.
Mhm.
And there are regulations arising under the Education Code, which provides that students participating in a school activity must be supervised at all times. Okay, fine, they're out there in this area between these buildings playing what the coach testified was a very dangerous activity. Two people throwing balls at one person at the same time. That's a dangerous activity. We never do that. That's not practice for baseball. That's just plain stupidity. So the question is, where was the supervisor? Oh, that guy over there sitting there on those steps. Oh, he's the guy that's assigned to lunch duty there. Okay, sir, what is your what do you teach? Band. I'm an assistant band teacher. Oh, really? What's your instrument? Trumpet. Do you have any background training or experience in athletics? No. What was your job when you were out there supervising way over there on those steps? I was just, make sure there's no trouble, like fights and stuff. Was that the complete extent of your duties? Yeah. You had no duty to supervise people playing any kind of recreational activity? No. Failure to supervise? The argument was whether there was consent to participate in a recreational activity. What was that recreational activity? The argument from the plaintiff was it wasn't baseball. That's not how you play baseball. And we heard the school coach say that's not how you practice baseball. So there's just three kids goofing off without supervision. That's what it was. Anyway, so on the eve of the hearing at which the trial judge was going to determine whether there was recreational immunity, a form of consent, the case was settled because neither side knew what that judge would do. and neither side was willing to find them. So, anyway, so that's happens all the time. Diving injuries, I mean, you just name it, it's unbelievable. Moore versus Williams, moving right along. Any questions about recreational immunity?
So when it says something about the matter of law in the.
Oh, as a matter of law means the judge decides, not the jury.
Okay.
There are,
Page 100.
oh, okay, thanks. Moore versus Williams. Supreme Court of Minnesota in 1905. This is a standard concept of consent. Somebody tell us in a nutshell what this case is about. Everybody should take turns speaking. It's what you do as lawyers. Even if you're an appellate lawyer, even if you're the intellectual quiet type who likes to sit at a desk and just theorize and write, and that's the main thing that you do is you write, which is great. But the day comes when you have to go into the appellate court and argue. Go right ahead.
Okay, Moore versus Williams. This case, and when we get to the issue, I'm kind of confused maybe a little bit there. But this case was the lady had gone to an ear specialist because she was having an issue with her right ear, is what it said at first. He said that the best course of action was for her to get an operation on the right ear. She went under the anesthetic. As he went to fix the right ear, he determined that the right ear didn't need to be fixed, but it was actually the left ear that needed to be fixed. And so when she woke up, she sued him for battery because she said she didn't consent for him to fix the left ear. There was an actual judgment on the plaintiff's behalf. I think that it went to the appeals court because the trial judge determined that the damages that were awarded were excessive in this case.
Mm-hmm.
Okay, so when I was looking at the issue, it was, do the doctor's actions constitute battery even in the case of the consent of the operator or of a different body part, or when the damages results are favorable? Is that true? I don't really know because they determined that there was a battery that occurred, but why it went to the appellate was because the damage was favorable, like you fixed the ear, and so I'm not quite sure what the issue is. That's
It was
what
a battery.
there was a battery, but the question was about that since her ear was damaged, that the intended result was for it to be better. The damages were too high, so I had a problem.
Well, that's different.
So was the issue battery consent?
Yeah, right.
Okay.
Consent to battery.
Okay. So
Not whether the damages were excessive.
okay. So it was, do the doctor actions constitute battery even in the case where consent for the operation was given, even though the outcome of what happened in that operation was different?
All right, and so the answer was she did not give consent.
She didn't give consent.
Okay, so she agrees to have an operation on her right ear, and while she's unconscious, the defendant says, "Oh, the right ear's okay, but flip her over here. We're going to have a look at the left ear." And her head open, okay, and decides better operate on that. And so, should he have woken her up and then asked, was there some life-threatening emergency? The court looks into that on page 101 in the middle paragraph. In the middle of the middle paragraph, which begins on the right-hand portion of that paragraph, it reads, if a person should be injured to the extent of rendering him unconscious, and his injuries were of such a nature as to require prompt surgical attention, a physician called to attend it would be justified in applying such medical or surgical treatment as might reasonably be necessary for the preservation of his life or limb, and consent on the part of the injured person would be implied. And again, if in the course of an operation to which the patient consented, the physician should discover conditions not anticipated before the operation, and which, if not removed, would endanger the life or health of the patient, he would, though no express consent was obtained or given, be justified. Such is not the case at bar. The disease condition of her left ear was not discovered in the course of the operation on the right, which was authorized, but an independent examination of the ear after the authorized operation was unnecessary, nor is the evidence such as to justify the court in holding as a matter of law, which means not as a matter of fact, submitted to the jury, that it was such an infection as would result in immediate surgery. There was no emergency. There was no hurry. It wasn't life-threatening. Yeah, maybe she would have said, oh, you woke me up for this, doctor, put me to sleep again. Or maybe she would say, gee, no, I don't want you to operate on my right ear, on my left ear. Yeah.
Well, and also, right, he sort of had no business looking at her other ear, you know, because it said it had to be found, like, within the confines of the surgery being done. And this definitely wasn't, because he just checked out her other ear, and there was no reason in this surgery to do that.
God knows what doctors do.
Exactly, like, why was he up in her left ear?
Right, but setting forth the principle of law on page 102, citing a treatise on torts about a little below midway through the central paragraph. As remarked in Jaggard on torts, every person has a right to complete immunity of his person from physical interference of others, except insofar as contact may be necessary under the general doctrine of privilege, and any unlawful or unauthorized touching of the person of another, except it be in the spirit of pleasantry, constitutes an assault and battery. Maybe not necessarily an assault, maybe you didn't see it coming, but certainly battery. So every person has a right to complete immunity of his person from interference of others, period. That's the rule.
So what you read on the previous, so I know how to read these cases, are those facts? What you read on the whole paragraph?
Oh, the previous page? Well, they're not facts. The court is saying these are hypotheticals. If a person comes into the doctor's office unconscious, can't get consent, consent is implied to allow the doctor to fix whatever has to be fixed in order to save this person's life or limb. Or if during the course of an operation, the doctor goes in to look at one part of the body, but it turns out there's something else that he or she discovers that's wrong and it must be corrected immediately, then consent is implied. But on the facts of this case, neither of those two hypotheticals apply. The facts of this case are there was no emergency. And the rule is that every person has a right to complete immunity of his person from physical interference of others. That's the rule. Okay. On the second trial, plaintiff received a verdict. Haha, I won. But what was the judgment for? $39. Okay, so must plaintiff be aware in order to give consent? Yeah, there can be no implied consent when plaintiff is unconscious, even if the touching is beneficial and necessary. A different result might follow if there's a serious risk of bodily harm. A reasonable person would consent. The doctor had no reason to believe he would refuse. Kind of like the Malloy versus Hop-Sang, where the well, in that case, it was the Chinese fellow who didn't give consent because he didn't answer, but he may have not answered because he was speaking English. Anyway. So looking at the notes on page 103, note 1, why did plaintiff's attorney sue under a theory of battery and not ordinary medical negligence? You have your hand up, Ms. Glazer?
Oh, no, I didn't. No,
Yes,
I
sir.
was, yeah.
The operation was successful. So therefore, he medically did it, as I think the book said, a skillful job. So really, he wasn't medically negligent in that sense. However, she did not consent to the operation.
There you go. There was no negligence. Note 4 is interesting. Medical care providers may act in the absence of express consent if the patient's unable to give consent, unconscious, intoxicated, mentally ill, incompetent. There's a risk of serious bodily harm if treatment is delayed. A reasonable person would consent to treatment, and the physician has no reason to believe this patient would refuse. No, it's Christian Scientists. They're the ones that don't consent. So I guess doctors are wary of that. Are you a Christian Scientist? Any Christian Scientists here? It's kind of I don't know how popular that religion is still.
I think Jehovah's Witnesses fit, right? Jehovah's Witnesses, I don't think go to the doctor.
Different altogether.
Yeah, but I don't think they go to the doctor either.
Christian Scientists,
Yeah.
It's kind of an oxymoron, really. But it's a group that was founded by Mary Baker Eddy in the early 20th century. I could be wrong about when it was founded, but they were very, very widespread in this country. The town where I grew up had a huge edifice. It looked like the House of Representatives. I mean, it was gigantic. It was a dome thing. That was the Christian Science. And all over the United States, there were, you'd walk down Main Street in a town, there would be a Christian Science reading room. So if you were dying of cancer, you would go to a doctor and you would go in there and read Christian Science literature about how you need to pray. Right? So, I don't know, maybe it's still popular, I have no idea. Maybe popular is not the right word for it. It's still widely followed, no clue. Let's see here. In note 6, plaintiff consents to an operation under general anesthesia on condition that her own physician be present. He was not. Is consent initiated? Good word. You don't run across too often. A jury verdict on battery was upheld. What if the plaintiff specifically insists the procedure shall go thus far and no further? For example, she consents to an incision and an examination of her stomach underneath her, but expressly forbids anything more. If the surgeon goes ahead and removes a tumor found there, is he liable? Schollendorf versus Society of New York Hospital, answer, yes. Every adult of sound mind has the right to determine what shall be done with her body. What if the patient limits her consent to female healthcare providers, explaining that her religious beliefs prohibit her from being seen unclothed by a member of the opposite sex? During surgery, a male nurse sees and touches her as part of a proper medical treatment. Liability for damage for battery, Cohen versus Smith, 1995, a violation of plaintiff's right to bodily integrity by unconsented to touching is the essence of battery. All right, so you can see from these notes and cases that this is a solid rule that's strictly applied in 1905 and 1995. What about note 7? May a competent, informed adult refuse medical treatment necessary to preserve, right? The answer is, yeah. Okay. Note 10, what happens if healthcare personnel ignore and do not resuscitate order? If the patient or his family has a cause of action for battery, what's the measure of damages?
This depends how horrible
What?
it is. Depends how terrible his life is after they save it.
Right. Plaintiff entitled to emotional distress damages for unauthorized transfusion. Where the battery is physically harmless, plaintiff entitled only to nominal damages, not compensatory damage for wrongful living or wrongful prolongation of life. We will see a number of cases in the textbook on that issue when we get to wrongful death. The issue arose a number of times whether you could have a valid claim for wrongful life. And the court said, we're not going there. Right? We're not God. We're not going to decide that your life should not have been lived, even if you think it should not have been. So, moving right along. DeMay versus Roberts. This is a nice case. What happens in DeMay versus Roberts? Who has not spoken tonight? Yes, sir. Well, actually, you did.
Oh, okay.
But you can go right ahead.
Okay. Oh, DeMay versus Roberts. So the facts of the case was plaintiff was giving birth. There was a doctor who was feeling ill. The weather was bad, so he brought a helper who was not a doctor. The doctor also informed the plaintiff's husband, or actually the husband, that he fetched a friend along the way to help him carry his things. The husband did not object, and the helper wrongfully and unlawfully touched the plaintiff. Here the issue is whether the plaintiff consented to the helper under false pretenses. And the rule that I got out of this was no one has a right to intrude on another unless invited, and that the plaintiff had a legal right and privacy in her apartment, and the law secured and required others to observe this and abstain from any violation.
Okay, very good. Back in 1881, and even today, occasionally you see the word guilty applied, but the word in tort law is liable, not guilty. That's in the closing down the hall. So, but with that caveat, on a dark and stormy night, it actually says that. It's a dark and stormy night. Just setting the scene, dark and stormy night. DeMay asked a young unmarried man to accompany him to the home with a baby anyway. They're admitted by the husband. The young man holds Plain's hand during the contraction. He's not the doctor's assistant. I thought it was the doctor's assistant. It was the guy she picked up on the highway helping push his cars. Did plaintiff impliedly consent to the young man's presence? No. In order for consent to be a defense, it must be voluntarily given. Full disclosure of all facts is required. Consent obtained by fraud is not a valid consent. Fraud vitiates consent. At the end of the civil code, there is a section called Maxims of Jurisprudence. Late on Saturday night, you had your fill of Black's Law Dictionary. Blackstone on the law, you got enough of that. Open up the California Civil Code to that. I think it's toward the very end. And read the Maxims of Jurisprudence. These are statutes that were passed. Why? I don't know. Back in the 1800s. My favorite one is superfluity does not vitiate. Your Honor, do you have any further argument? Yes, Your Honor. Superfluity does not vitiate. And well said, counsel. Maxims of jurisprudence. Everybody done with this? Okay. Notes and questions? Note 1, the court says that the plaintiff consented to Scattergood's presence for supposing him to be a physician, and that defendants introduced him without fully disclosing his true character. In order for consent to be valid, how much does defendant have to disclose? What if the plaintiff asks no questions? Under what circumstances can consent be assumed? A breast cancer patient on a routine visit to her oncologist is shown into a private examining room. Her doctor arrives, accompanied by another man who is introduced as someone who is following his work. She says nothing. Following her doctor's instructions, she disrobes and he examines her breasts and lower abdomen in the other man's presence. As she leaves the office, she asks the receptionist who the other man is and is told, he's a drug salesman. Is there consent? That was Sanchez versus Alza Pharmaceuticals, because the true status of the drug company representative was not disclosed, no implied consent. Even though she didn't object, she made an assumption. So that's incredible. Note 2 is another bizarre scenario. Defendant calls on plaintiff, a woman with an artificial leg, in her house. So good thing they had that comma after leg and before in, otherwise it would be, she has an artificial leg in her house. It's over there in the corner. Representing himself to be a doctor referred by the company that made her leg, he induces her to remove her dress, expose her person, and to permit him to touch her. He is in fact a doctor, but of theology. Is that a battery? So you can look that case up. It's a very bizarre circumstance. This doctor of theology has a habit and custom of doing this. Consent not valid because defendant led plaintiff to believe he was a doctor. He was not. How about defendant gives plaintiff some chocolate candy which contains an irritant poison, ignorant of the fact plaintiff eats the candy and is made ill. Liability for battery, of course, consent's not valid because the facts were not given to her. Note 3, suppose A consents to sexual intercourse with B in ignorance of the fact that B has a sexually transmitted disease. A contracts the disease. Has she a battery action against B? What do you think? That is the case of Kathleen K. versus Robert B., 1984. I believe the answer would be yes. Anyway, those are interesting permutations on the theme of consent. Note 8 on page 109, can you consent to illegal activity? In contracts, have you gotten to illegal contracts yet? No. We had an agreement. You were going to drive the getaway car, and I was going to do the whole thing. And I came out, and you weren't there. You breached our agreement. Wrong. You can't have an agreement to commit an illegal act, not an enforceable contract. Plaintiff consented to participate in a prize fight, an illegal activity in the state. He died as a result of a blow received in the fight. His estate filed a battery claim against the other fighter, who demurred on the basis of consent. Is consent to an illegal act a valid consent? And in that case, recognizing the split of authority as to whether consent to an illegal act is valid, is a valid consent. So who knows what it would be in any particular instance. jurisdiction. What about self-defense? Have you got that far in criminal law? Self-defense? No. We should go through this. Anyone is entitled to use reasonable force to defend himself against a threatened battery on the part of another. When the battery threat is no longer, when the battery is no longer threatened, the privilege terminates, even where the aggressor does not retreat. The person must have a reasonable belief. So, the reasoning in Ransom versus Kidner, the case we just looked at, mistake does not, no, it's an earlier case, mistake does not negate intent, does not apply because of the importance attached to importance of self-preservation. Detached reflection in the face of an uplifted knife is not required. So it must be a reasonable belief that you are about to be struck, and then you can use reasonable force to defend yourself. So self-defense is a defense to battery. I can make this available another time. Generally, provocation does not justify the exercise of self-defense. An exception might be words accompanied by an actual threat of violence. So, somebody makes you very angry. Does that mean you get to employ defense of self-defense just because you're angry? No. The force must be reasonable. Retreat is necessary for the use of deadly force. You have to retreat. It's only when you can't retreat that you then can use deadly force. Except in Florida. And defense of others. General rule is that one who intervenes to help a stranger stands in the shoes of the stranger. And if the person aided is the one at fault, the intervener is not justified in his use of force and is liable. So if you see somebody beating up on another person, you jump in to assist that person, but it turns out the person you're assisting is the actual aggressor. You stand in the shoes of the person you're defending. So, when you see two people in a brawl, excuse me, sir, wait, which one of you started? Some jurisdictions hold defendant privilege to use reasonable force to defend another, even if he's mistaken, so long as it was a reasonable mistake. So, these are just kind of common sense things, don't you think? Yeah. Mr. Watson, you look like you're bored in tears.
Oh, no, I'm not.
This stuff is, it's so commonsensical. You think, yeah. Anyway, this is a great case. This is one of those court cases that you never forget. Defense of property. I remember this case. I love going to law school. I love the classes. They were all just a blast. I love criminal law, criminal procedure. And I like property law. I like everything except sales. And what was the other thing associated with it? You know, commercial transactions left me just looking at my watch. You know, I don't get it. You know, but the rest of it was really great. And in torts, I remember the professor when we were talking about this. Crazy guy. Ketco versus Briney. Who wants to tell us about this wonderful case? Yes, ma'am.
Yeah, this case really upset me, to be honest. So the issue was, can an owner protect his property against trespasses and theft by a spring that is capable of inflicting death or serious injury?
Mm-hmm.
And so the facts.
And there's Mr. and Mrs. Edward Briney just in front of their baby now, in case you doubt it.
Yeah. Okay, so. Okay, so it was an abandoned abandoned property several miles from the defendant's home. And it had been known people kept going in there to steal things. And in fact, the plaintiff had gone in there to steal things before. And there were no trespassing signs outside the property. And so what the defendant did, because he was tired of people going in and stealing things, was to set up a shotgun trap that was like spring loaded to the door. So if anyone tried to open it, they would get shot. And he did deliberately make the decision to aim it at the legs instead of, the head or the chest or somewhere. But so plaintiff tried to open the door, and he got shot in the legs. He had a permanent deformity because of that. And the defendant argued that the law permits spring-loaded guns for the purposes of preventing unlawful entries. So what the court decided was the value of human life and limb so outweighs the interest of a possessor of land. And there's no privilege to use force intended or likely to cause serious harm against another whom the possessor sees about to enter his premises or meddle with his chattel, unless the intrusion threatens death or serious bodily harm to the occupiers or users of the premises. So basically, if there are no people around and the person's not going to harm any of the people and it's just a harm to property, you can't kill them or seriously hurt them.
Cannot use lethal force in defense of property.
Right, because the person's life is more valuable than the property.
Right.
But my point on this, I mean, I don't know, like he was going to steal stuff. Like he kind of got, like, isn't that on him?
What's the rule?
I know, that's not the rule, but I'm a little upset by the rule.
That's the rule.
I know, yeah, I was surprised to find out that I agree with stand your ground.
Right.
Because in Florida that, well, no, it still won't be allowed, right?
You can
Because
stand your ground,
you have to
as
be
objectionable as those cases may be. The defense is that human life was threatened.
there.
You don't stand your ground
Mhm.
to protect your television set. Okay?
Maybe it's like the person is in there, like intending to commit a crime against you. I don't know. That makes sense.
Lethal force cannot be
No,
used
not
in
lethal,
defense of
but
property.
he wasn't using lethal
That's
force. He just shot him in the leg. And I mean,
That was a very good point.
Just
So originally, as it says on page 115, Mr. Briney hooks it up, wires it to an iron bed, points the gun at the bedroom door, rigged so that it would fire. So Briney first points the gun so an intruder would be hit in the stomach.
right, but he changed it
But
on purpose to
but-
be less harmful.
at Mrs. Briney's suggestion,
Yeah.
oh, what's his first name? No, oh, Edward. No, please lower the gun. I would feel bad. So just blow his legs off.
Yeah, so he thought
And
about
he'll
it.
at
Like,
least he'll still be able to walk. He'll still be able to live, he just won't be able to walk.
but I mean, it's just crazy to me that somebody could be committing a crime against you, and then you end up having to pay all this money
It's
to
not
them.
against you, it's against
It's
property.
against your property,
Right,
but like,
Fine. So
it,
it hits him in the leg. Hitting him in the stomach actually is a horrible thing. I mean, if you get shot in the stomach, it takes a long time to die, and it's very painful.
listen, you didn't do it.
What?
You didn't do it.
Anyway, the point is, you can't put a spring gun there, and you can't do that. You can't use lethal force in defense of property. That's the rule.
Mhm.
That's all you need to know.
Mhm.
So, I knew this guy years ago up in the Bay Area. He lived in one of these duplex apartments where you've got an apartment downstairs, two doors, one that goes to the downstairs, and the other one opens to a staircase, and there's a second floor apartment. And this guy's sitting up there playing piano. He's a very bizarre character. He plays impassable piano, playing his little Bach in 2 or 3 part inventions. But he has next to his piano a rifle. He just likes to have it. Okay. He hears somebody breaking and entering at the bottom of the staircase. So he interrupts Mr. Bach, takes the rifle, and he stands there. And when the guy comes up the staircase, he's standing there pointing the rifle. The guy turns and runs, and this fellow then goes down the stairs, goes down the sidewalk, and shoots him. The guy's running away, hits him in the leg. Police come out, and they say, you know, you should not have done that. Unless you should, actually what they said was, you should have shot him when he was inside, right? Because now that's a threat to you personally, right? Potential violence against your person. But once he had fled, you can't shoot him, right? Defensive property. So years ago, my father was had hunting guns, and he lived in this, at the end of the street. People would come up there and try to break in, and he told me, he said, you know, next time somebody does that, I'm going to shoot him. I said, just please don't do that. You know, just, he said, no, I'm going to kill him, you know. And so somebody, he hears some commotion in his driveway, and he gets up, and he has shotguns, and he opens the upstairs window. Pulls the trigger. He doesn't hit anybody, but, you know, he blew the gun on. And I told him, I said, you know, I was in law school at the time, I was taking Florida. I said, honestly, if you do shoot him, go out there and drag his body into the house. That's it. Can deadly force be used just to scare someone away? See note 5. Let's look at note 5. Principal case caused a good deal of discussion about when, if ever, force calculated to cause death or serious injury may be utilized to defend property. Cases involving burglars or thieves attempting to recover their intended victims are rare. So that doesn't really answer the question. Note 5F. That's on page 119. What if the landholder claims he intended only to frighten and not to injure the intruder? Someone acquaintance who fired the gun as this guy was running away. What if he didn't intend to hit it? How does this correlate with the doctrine of transferred intent? Defendant argued he did not think the 2 sticks of dynamite buried in the floor of the tool shed would injure him. Well, that's a good one. In Goldfuss versus Davison, defendant yelled at men he saw running away from his pole barn and fired from his kitchen window warning shots over their heads to try to get them to stop until the police arrived. One of the men was killed, and his father filed a wrongful death action. The court found no prejudicial error in the trial judge's instruction that the jury was to determine whether the defendant's discharge of a firearm was reasonably necessary to prevent the theft of his property. The jury awarded $150,000 to the estate of the thief. So, question of fact gave it to the jury. Surprising. Going back to note 1, and then we'll move on page 117. Whatever happened to Catco? Catco pled guilty to petty larceny and received a 30-day suspended sentence and a $50 fine. The Britneys had to sell 80 acres of their 120-acre farm to pay the judgment in the case. A strange development later arose between the parties. When the 80 acres were put up for judgment sale, and there were no bids above the minimum price of $10,000, and the judgment was for $30,000. 3 neighbors borrowed money to purchase the land for $1 more, $10,001, expecting to hold it for the Britneys until they won their appeal. When they did not win, the neighbors leased the land back to them for enough to pay taxes and interest costs on the money the neighbors had borrowed. Several years later, when the land value rose, the neighbors offered to sell it back to Brittany at a price they couldn't afford. Fine neighbors. One of the neighbors then bought the property from the others for $16,000 and sold it to his son for $16,500. The Brittnys and Catco, to whom the Brittnys still owed money from the judgment, then sued the neighbors, arguing that the land was being held in trust for Briney's, and that they were therefore entitled to the profit from the increase in value. Just before the case came to trial, it was settled for a sum large enough to pay the remainder of the Briney's judgment. So, my God, their neighbors say, don't worry, Mr. and Mrs. Edward Briney. We'll see that your land is protected, and then when everything blows over, we'll sell it back to you for its fair market value at the time. Fine neighbors. All right. Let's move on to defense of property. So we can get out of here tonight. Let's just power through this. Plaintiff purchased a stove on credit and left the defendant's warehouse with the stove. Right after he left, the defendant discovers that plaintiff had misrepresented his assets. Defendant took off after plaintiff, caught him 2 miles down the road, and used force to take back the stove. So, can you use force to retrieve stolen property? If so, how much force? So, looking at the language of the case on page 120 at the bottom, in this case, before us, it is stated that it did not appear, quote, how much force was used or its character before defendants were assaulted by plaintiff. They're trying to get the stove. Wait a minute, who's trying to obtain possession of the property in question? No violence to the person of the plaintiff was necessary or required unless from his resistance. Plaintiff had no lawful possession nor any right to resist the attempt of defendants to regain the property, of which he had unlawfully and fraudulently obtained possession. By drawing his knife, he became the aggressor inasmuch as he had no right to protect his fraudulent attempt to acquire the stove, and it was the right of defendants to hold him by force if they made no use of no unnecessary force. So he lies about his assets, he gets the stove through fraud, they come after him, he defends property which is not his with a knife, they attack him. All right, so he then sues them for attacking him and saying, I was defending my property. Can a party use reasonable force to recover chattel? Yes, the party can use reasonable force to recover chattel immediately after it was taken. Why not later?
Because the reasonable time is expired.
Well, that's kind of circular answer. I don't know.
That's okay, yeah.
No, I mean,
It is that after the time it expired, there's other systematic, like there's other.
that's called a court system.
Right. Right. That's it.
You sue it for conversion or whatever else you want to sue for. That's how you get. Self-help is frowned upon. The law is in place to prevent people from exercising rights of self-help to retrieve property or otherwise obtain redress for wrongs, because people get hurt. Just forget the damn thing. Just sue him, right? Get a judgment for the stove. You'll get it. Send the marshal out there. Let the marshal get the stove. Okay? Much easier. I like that answer because a reasonable time is.
That was a bad answer.
No, it was I was watching a comedic episode with Jay Leno, who liked to go out in front of his studios and ask people questions and then videotape their ridiculous answers. One of them was, he asked somebody who just graduated from college, if it's September in the northern hemisphere, what month is it in the southern hemisphere? They were like, December? And another one was, I was just thinking about this. They'll come together. Let's move right along. Kowski versus Harlan's department store. Somebody tell us about that, and then we'll power, once we get through recovery of property, we're going to power through necessity, of necessity. Somebody tell us about Kowski versus Harlan's department store.
I can.
Go right ahead.
Okay, so a plaintiff is suing for false arrest and slander against the defendant, whose agent stopped her for suspicion of larceny and was questioned. She denied she had taken anything. He proceeded to look at contents of her purse while she emptied it. As a result, plaintiff suffered intentional emotional distress. The department store sued the officer who defaulted, and the issue is whether or not an agent or merchant has the privilege to arrest when there is reasonable belief for unlawfully possession of goods. And the rule I chose is a privilege in favor of a merchant to detain for reasonable investigation of a person whom he reasonably believes to have taken a chattel unlawfully.
Reasonably believed it to be the case. That's it, shop. Something in the nature of shopkeepers.
Oh.
Private security guard stops her, plaintiff returns to the store, is told that another had reported plaintiff had stolen some costume jewelry. She produces the receipts. They let her go. She sues for false imprisonment and slander. Does the shopkeeper have the right to detain? Yes, the shopkeeper has the right to detain a person whom he or she reasonably believes to have taken a chattel unlawfully for a reasonable period of time. That sentence needs some reworking. It's not that the person took the chattel for a reasonable period of time, but rather that the shopkeeper has a right to detain a person for a reasonable period of time if the shopkeeper believes that the person has unlawfully taken chattel. So, why do we have that? Shoplifting is such a serious concern that folks said we're going to make an exception. Now we move into necessity, Sirocco versus Gary. Mayor of San Francisco orders plaintiff's home blown up to stop the progress of a raging fire, sues for damages. This is the Great Fire of San Francisco in 1853. Must the government compensate a private party for damage to property destroyed by an act of public necessity? Answer, no. Generally, in the absence of legislation providing for compensation, those whose property is destroyed by an act of public necessity, there's no right to compensation. So, in that case, there was this huge fire in San Francisco, a city made of wood, and in order to stop the progress of the fire, the mayor ordered that a series of buildings be blown up, keep the fire from crossing over to the other part of the city. And the mayor can do that. Who's the mayor? Gary. It's very interesting. The mayor was Gary, who at that time was the alcalde of San Francisco. In 1853, they didn't have mayors, they had alcaldes, because it was fresh after the Mexican-American War when much of the language used in California was still that of Spanish-speaking Mexico. Public necessity. Vincent versus Lake Erie, Supreme Court of Minnesota. Defendant deliberately tied a ship to plaintiff's dock during a storm, causing damage to plaintiff's dock. Sounds like a necessity. Damages to the dock. And the court said, must a private party compensate a private party for damages to property destroyed by an act of private necessity? Contrast that with the Holiday of San Francisco, who is exercising a right out of public necessity. The answer is yes. A defendant acting on private necessity is relieved of the technical tort, in this case trespass, but must provide compensation. I had to tie my boat up to your dock. There was a storm. I'm sorry about the damage to your dock. The court says, okay, fine. You don't have to. You're not liable for trespassing, but you're going to have to pay this guy for the damage to the dock. I mean, why should he bear the burden of that? So, the philosophy in forming that decision is succinctly set forth on page 130 in the second full paragraph, beginning with the words theologians. Theologians hold that a starving man may, without moral guilt, take what is necessary to sustain life. But it could hardly be said that the obligation would not be upon such person to pay the value of the property so taken when he became able to do so. And so public necessity in times of war or peace may require the taking of private property for public purpose. But under our system of jurisprudence, compensation must be made. So the same principle applies in this particular case. And then we get into authority of law. Let's skip over that and get into justification. Sindel versus New York City Transit Authority, the last case for the evening. And this is the case where the plaintiff, 14 years of age, boarded a school bus owned by the City of New York Transit Authority. Last day of the term at Elias Bernstein Junior High in Staten Island. The students are on board the bus were in boisterous and exuberant mood. Some of the spirit expressed itself in vandalism, students breaking dome lights, windows, ceiling panels, advertising poster frames. No evidence plaintiffs took part in that destruction. So the driver closes the doors of the bus and passes several more stops. Plaintiff sued for false imprisonment. So defendant claims necessity is justification of defense to the intentional tort. Defendant's action may be justified if the actions taken were reasonable and done to protect others from personal injury or to protect property. So on page 136, the court says in the second paragraph, we note that generally restraint or detention reasonable under circumstances and in time and manner imposed for the purpose of preventing another from inflicting personal injuries or interfering or damaging real or personal property in one lawful possession is not unlawful. That's it. That's the rule right there. And so the school bus driver acted reasonably to protect public property, the school bus. No false imprisonment here. So that's as far as we get. Very quickly. Any questions on that? Pretty elementary. So here is a very simple fact pattern. We won't spend much time on it. out of here, but pass it out. Have a look at this, jot some notes down. You will know what you think the legal claims are, if any.
Yeah.
If any. There may be none. How about that? Very quickly write down what you think the torts are. That's a dead giveaway. I'm letting you know there are no contract questions here, no criminal law questions, no constitutional law questions. What torts that we have studied thus far, and we've just done the intentional torts, what torts are there possibly, potentially, and what are any defenses, if any? What are the torts? There aren't many.
Trespass.
Push the pencil over the surface of the page. Once you've written down all possible torts of the kind we've looked at so far, then from memory, if you can, or if not, look it up, write down the elements of each of those torts, assuming there's more than one, and then ask yourself whether the elements of those torts have been met by the facts. I'll give you a heads up. First element of each of the torts, if any, would be intent. Okay, folks, so you want to tell us what one of the bullets might be, and who has it against him? Go ahead, sir.
First court, Professor Trussell was paid to trespass the land. And the three elements were intent to go onto the land or enter it. He didn't have permission to enter, so he was unauthorized entry. And he actually went on the land. And that was the first.
So let's stop there. So the intentional entry upon the property, possession, not without consent of legal privilege. So Bob intentionally went onto Sally's land, right? So the element of intent is met, right? However, Bob got.
I'm sorry, I was lost in my thoughts. I was gonna.
That's you did go to all the time. Go ahead. I'm sorry.
No, please. You were taking me somewhere. I'm sorry.
What's Bob's defense?
Oh, Bob's defense was that he didn't know. So that he didn't know he was on his property. He thought he was on his property.
Mm-hmm.
But that's not a defense.
Right. So what's your conclusion?
He's guilty of.
Okay, we say liable.
I'm sorry, liable to, that's down the hall, right? Liable for trespass to land.
Okay, so she has a good claim for that, right? So, the intentional entry of trespass. Sally may have a viable claim for trespass to land, which is defined as the intentional entry upon the property in possession of another without consent or legal privilege. Here, Bob intentionally went onto her land. The fact that he thought it was his is no defense. The state is no defense to this intentional tort. And so it was in Sally's possession. It says it was Sally's land. It doesn't say anybody else had possession of it. There are no facts showing that Sally gave him consent. There are no facts showing that Bob had a legal privilege. Therefore, Sally's be brought? Yes, sir?
For IDD, intentional infliction of emotional distress
Okay.
can also be considered.
What are the elements for IIED as best as you can?
Yeah, the rule I've got, a person is liable for intentional infliction of emotional distress if the conduct is so extreme and outrageous to be the substantial case, the substantial cause of severe emotional distress.
Okay, there it is. And so what do the facts tell us?
All right, so the facts tell us that that Sally, when finding out this spanner had gone missing, is beside herself with distress, and that's the claim. And so I suppose the issue is whether this was whether the removal of the spanner determined.
Well, no, the issues are determined by the elements. So what's the first element? Of intentional infliction of emotional stress is intent.
Okay.
So the first issue is whether Bob intentionally or intended to cause her emotional distress or intentionally committed an act reasonably certain to lead to her emotional distress. What do you think? What's your conclusion based on these facts?
It's going to have to go to finding for the jury. Like a matter of fact has to be decided.
What question? Okay. What case comes to mind tonight?
Specifically,
Not the name of it, just what.
I cited Taylor v. Valley.
And which one was that?
That was the party is liable for emotional distress when one acts for the purpose of causing, with the knowledge of the substantial.
Okay, but what? We had a case tonight where the lady's father's beaten up.
Yes.
And she sues, that you intentionally caused me emotional distress. And the court said they didn't know you were there. Okay. So where is Sally?
She was not there.
Not there. So Bob's defense would be, I didn't meet the element of intent to cause her emotional distress. She's nowhere to be. I didn't commit any act that she would have been present for. However,
I guess me as a prosecutor, I should say that anyone who her emotional distress is as a result of her property being disturbed, not necessarily the spanner.
we'll go back to the intent. Just talk about intent. You're not a prosecutor. You're a jury representing her.
Okay.
You're trying to show he committed an intentional act, and he didn't even know, she wasn't around, she didn't witness it. Is there any evidence that would show that he intentionally committed any act that was reasonably certain to result in harm to her?
And I would say it's arguable, and I'm trying to give you the
Go ahead.
case that might be arguable, is that I think it's arguable because anyone would know with substantial certainty that the entry onto someone's property and moving their property should knowingly cause someone distress, that they know someone's in their home.
Okay, so there it is. So you would argue, that's very good. So Sally will argue that this is, though he lacked the specific intent to cause her emotional distress, he had the general intent to commit an act that was reasonably certain to cause distress in the property owner, right? Okay, right? Okay, anybody? Yes, sir.
Wouldn't his intent come into place because when he re-entered to return the items, once he found out it was, he did that to kind of.
Well, that's a good question.
Yeah.
Hold that thought, whether he committed 2 acts of trespass.
Right. But I'm just saying, wouldn't the intent be shown there because he's saying, whoa, that's not my stuff. I don't want to cause him distress. And so by doing it.
It's an argument. Plug it into what he said. Okay. Moving on. Intention. What are the other elements of it? The other elements are extreme conduct. So what would you say about these facts as to the element of extreme conduct?
Me as a reasonable person, would say,
Yes, you're a very reasonable person.
That's the establishment is the subjective objective test. Is
would that be what applies here?
It's an objective test whether or not the conduct, whether a reasonable person would see Bob's conduct as extreme and outrageous and beyond the bounds of civilized activity. Right? The facts here show that he walked in and onto land which he thought was his, went into a shed that he thought was his, and took a tool that he thought was his. That's not an extreme and outrageous conduct. And so that element for IAD is not met. How about severe emotional distress? Will she meet the element, do the facts show that she will meet the element of severe emotional distress?
Yeah, she was beside herself.
Okay. She has a nervous breakdown. So there's the intent element, there's the conduct of the defendant and the distress of the plaintiff. The facts support 1 out of 3 elements. So what's the conclusion?
It was not reasonable.
Yeah, you have to have all 3. So no IIED. What's another tort?
Trespass to chattel.
Trespass to chattel. What do you think about that?
There was, it wasn't intentional. So, well, I mean, I guess he intentionally took it, but he didn't know it wasn't.
How are you going to write this? Sally may have a claim against Bob for trespass to chattel. The elements of this tort are intentional damage to or interference with personal property, possession of another without consent or legal privilege, beginning with the element of intent, according to the fact show. What would you say?
It depends because he didn't intend to damage or interfere with her personal property.
Is that the intent? You have to have the intent to damage the property?
Or to interfere with it. He thought it was his own, but he did intend to pick up that specific.
Right. So the intent, the element of intent is met. He intentionally picked up that thing and took it back off of her property to his property. So he met the element of intent. What about damage to or interference with the personal property?
Yeah, he interfered because she couldn't use it for the period of time he had it, and we don't know what period of time that was.
So was the wrench damaged?
I don't believe so.
Yeah, he took it to his garage and placed it on his workbench. No damage to the spanner wrench. Okay. What about interference with her property? Was there some substantial interference with her property or use of the property?
Not the property, but her use of the wrench, because she couldn't use it.
Okay, where did he find this?
Oh, in her garage or shed.
In an old shed. He's wandering around. There's an old shed, and he goes, "Oh, this is a nice wrench." You would argue that he didn't interfere with her use of it. She wasn't dispossessed of the tool. She probably didn't even know it was there, right? You don't know that, but the facts suggest that Bob could argue that there was no substantial interference with her use of the tool. Okay, or otherwise he did take it from her property. So there's no evidence for consent or legal privilege. So what would your conclusion be whether he would be liable for trespass to chattel? It doesn't matter what your conclusion is, just make one.
Because even if she didn't know about it, had she known about it, she wouldn't have been able to use it. I think maybe that doesn't matter.
Here's, you got to reach a conclusion and you can't get wandering.
Sorry, yeah, he would be liable for trespass to chattel.
I think so.
I think so.
Okay, so Bob, my conclusion is that Bob may be liable for trespass to chattel because he did take the wrench to his own place, thereby dispossessing her of it so that she couldn't use it. That's your conclusion, that's fine.
Okay.
Doesn't matter what your conclusion. Somebody else might argue the tort of trespass or claim for trespass to chattel will fail. There is no evidence that the spanner wrench was damaged. We know that actual damage to chattel is 1 element of the tort, or in the alternative, substantial dispossession of the wrench. Here, there's no evidence that she was using it or even knew it was there. All he did was take it back to his place, set it down, realize his mistake, and put it back, so she would not prevail on trespass to child because she can't meet the element of damages. Conclusion, boom, move on to the next one. Right. Just you've discussed all the facts, you pointed out what all the torts are, you told us what the elements are, you plugged in the facts to each of the elements, you reached a conclusion, right, wrong, or indifferent, and then you move on. Judge Evans likes to call it going to Jiffy Lube. Get in there, you get your oil change, and you get out of it, right? Just get in there, discuss the facts, discuss the tort, put in the elements, and out. Because there's no time to dwell upon, well, it could be this, it could be that. You don't have time. Makes sense? So, for the most part, Sally has a crappy case. What is she going to get? Well, she's going to get a prevailing trespass to land. Does she have any actual damages? No. She's going to be entitled to nominal damages, $1. Right? She's a nutcase. She has a nervous breakdown because of a spasm. Okay. Write out this thing. Take the time and write it out by hand. If you don't mind to type. Bring it, shoot it over to me. Practice. This thing with Jay Leno is very interesting.
Everyone writes different.
He stops these people. There's some place out in Hollywood, and he stops these people.
Because that's what I did, and how it happened. So, like on all my stuff, like you remember how she said
that we should,
so I have,
North Korea.
I know,
Went out there.
but you see, it's just that it's scattered everywhere. Not every person writes the same. So how she said procedural facts, use that.
Suppose you're in a race.
For every,
Run past the
every
second place. What place are you in?
remember how she said first?
First place, right?
Yeah. So whenever you always, she said first, right?
Are you getting laughed?
This is you run, you're in a race, you run past the person in second place.
So that will help you.
Place are you?
Because that's what, yeah.
Second place. You just ran past.
Yeah.
You didn't run past first place, you ran past second.
Are you in the race? Are you just running?
Maybe that'll help.
This is another. Nailed this guy.
And then I waited.
It's okay. Farmer has 15 sheep. All but 8 of them died.
I took
How
them
many
out.
sheep does the farmer have? Right. Somebody said,
all but 8 of them died.
people say, I did try this on my 8-year-old grandson. He said, wait a minute, 15 minus 8. Then I can't do the calculation. There are no calculations.
That's what I thought. I couldn't go to 15 minus 8.
Forget it.
You don't watch it. I never had a job.
You guys never had that.
It's very impressed.
You too.
Talking about Caitlin.
She's more.
This is the reasonable standard.
Yeah, it's not, maybe that's it. Maybe that's what is so attractive about it. It's not philosophy, it's not all this ephemeral stuff. But nuts and bolts. Nuts and bolts. Roll it out or roll it in.
Yeah. Well, I realized too, trespass to chattel, because she'd be suing for nominal damages, you can't, I forgot that, you can't sue, yeah. So it wouldn't have, yeah, I changed my answer.